Welcome to the Judiciary Committee. If you don't know, it is the best committee to ever be in the legislature. My name is Senator Wayne. I represent Legislative District 13, which is North Omaha and Northeast Douglas County. And we will start off by having senators and staff do self-introductions, starting to my right.
Good afternoon, Senator Terrell McKinney, District 11, North Omaha.
Carolyn Bodson, District 25, which is Lincoln, Lancaster County.
Engineer Pierre Lewis, Committee Clay.
Hi, everyone. Good afternoon. My name is Wendy DeBoer. I represent District 10 in Northwest Omaha.
Rick Holdcroft, District 36, West and South Sarpy County.
Barry DeKay, representing District 40, which consists of Holt, Knox, Cedar, Antelope, northern part of Dixon County, northern part of Pierce County.
Also joining us today are our committee pages, Isabel Cole, who is a political science and pre-law major at UNL, and Ethan Dunn from Omaha, who is a political science major at UNL. This afternoon, we'll be hearing 5 bills, and they will be listed in order outside the room. To my right, by this column over here, there are blue testifier sheets. If you are planning to testify, please fill one out and hand it to the pages. That'll make sure that we have accurate records. If you don't want to testify, but you would like to record your presence, please fill out a gold sheet. Also, it is our policy that all letters of records must be submitted by 8 a.m. the morning of the hearing. Any handouts submitted by testifiers will be a part of the exhibits. If you have handouts, we ask that you have 10 copies. If you don't have 10 copies, please give it to the page ahead of time so that way we can have those copies for the committee during your testimony. Each testimony we'll begin every bill with the introducer's opening statement, followed by proponents, then by opponents, then by those testifying in a neutral capacity. After that, if the senator chooses to, they can have closing statements or they can waive closing. We ask to make sure all testifiers please state and spell your last name so we can have them for the record. Also, we'll be using the 3-minute light system. Starts off as green, 1 minute left, it'll turn yellow, and at the red light, we will ask for you to wrap it up. I would like to remind everyone, including senators, to please turn off or silence your cell phones. And with that, we will start with LB 1185. Senator Lowe, welcome to your Judiciary Committee for the last time.
What happens if I come back?
Yeah, that might be a problem.
Yeah.
Well,
Especially with my wife.
I understand.
Chairman Wayne and members of this great Judiciary Committee, what an honor it is to have my last bill of my 8-year tenure before you. My name is John Lowe, that's John Lowe, and I represent District 37, which includes Kearney, Gibbon, and Shelton. This is my last session as a state senator, and I just could not end my time here without bringing just one more bill to my favorite committee. LB 1185 is a bill that I decided to bring after having discussions and meetings with law enforcement officers throughout District 37 and the state. They have concerns with individuals who will come up to them during the middle of a traffic stop or during other official interactions with an individual and shove a camera or phone in their face. This is a problem. This behavior not only causes problems for our police officers, it causes what could be a dangerous situation. My initial reaction after hearing from our police officers was maybe we should just ban this type of interaction outright altogether. It is my understanding that there have been several U.S. appellate court decisions that have made clear that citizens have the right to record police officers as they work and interact with the public. But I also believe there's a pathway that allows for citizens to record police officers during their official duties, while at the same time giving our officers and those that they are talking with some breathing room and for the state to step in and create a clear pathway to de-escalation. 1185 makes it an offense of obstructing a police officer if a third party is recording the officer within 10 feet of the officer's interaction. 1185 does not prohibit the recording. LB 1185 does not prohibit an individual from being, who has been stopped or pulled over by an officer from recording the interaction. LB 1185 says that a third party must maintain a 10-foot buffer if they're going to record the interaction. I believe that LB 1185 creates a safer environment for our police officers, for the individual who has been stopped by the officer, and all ensuring that third-party individuals maintain the right to record and provide citizens oversight of police officers. With that, I'm happy to answer any questions.
Any questions from the committee? Seeing none. Will you be here for closing?
Of course.
Okay, thank you. First proponent. Welcome back, sir.
Thank you. Thank you. Good afternoon, Senator Wayne, members of the committee. My name is Terry Wagner, Terrywagner. I'm the Sheriff of Lancaster County, and I'm here today on behalf of the Nebraska Sheriff's Association, the Police Officers Association of Nebraska, and the Police Chiefs Association of Nebraska. LB 85 would provide a safety zone for officers actively involved in law enforcement work. Nothing more, nothing less. There are those who would say this bill was introduced because law enforcement doesn't want to be recorded doing something wrong or denying individuals' First Amendment rights. On the contrary, we welcome being recorded. We've had in-car cameras for over 30 years and body-worn cameras for over the past decade. These recordings have been invaluable in clearing officers of false accusations or wrongdoing and providing photographic evidence in court. On rare occasions, officers' misconduct has been uncovered and dealt with. We actively solicit video recordings by citizens at the scenes of crimes for their evidentiary value. Let's look at the reasoning behind the introduction of LB 1185. If you can, imagine yourself attempting to take somebody into custody. They are resisting and the struggle is on. As you're working to overcome their resistance, a person you don't know, whose intentions are unknown, whose relationship to the arrestee is not known, gets very close and holds an object in front of them 1 or 2 feet from your face. I can guarantee the officer's total focus needs to be on the struggle before him or her, and now his or her attention has to be divided to determine whether this person holding out the object is a threat or not. Should the citizen contact turn into a deadly force encounter, the person videotaping the contact within 10 feet could be in great danger. Likewise, if an officer is first on the scene of a crime and begins medical first aid for the victims or begins conducting a crime scene investigation, citizens should not be closer than 10 feet to prevent interference with medical personnel or contamination of the crime scene. LB 1185 simply provides that safety zone so officers can focus their attention on the task at hand and not have to worry about any outside interference. If someone wants to video an arrest, they can safely do so from 10 feet away under LB 1185. Thank you, and I would be glad to answer any questions the committee might have.
Any questions from the committee? Senator McKinney.
What's the current law on this? Like, if somebody is currently recording officers, what's the current distance that they are required to be?
There's some distance, Senator. Most people use good sense and stay a ways away, but in some cases, somebody videotaping an officer could get right up next to them at either a traffic stop or scene of an arrest or any kind of encounter.
How often does that happen?
Well, it happens all the time. I mean, media is very good about following our directions on our request to observe the zones we have set up. And, but it's becoming more common when there are citizen encounters where folks will regularly videotape officers. And in some cases, just get right up close to them. I know it's happened. I don't know how often.
So there's no data to say how many times per year somebody, when an officer is making an arrest or a traffic stop or wherever, somebody is recording an officer or trying to record an officer, how many occurrences is somebody getting under 10 feet or less?
I have no way of knowing that.
Okay. Thank you.
Since it's not a crime, nobody keeps statistics on that.
Okay. All right.
Thank you, Senator McKinney. Are there other questions from the committee? I don't see any. Thank you so much for being here.
Thank you.
We'll have our next proponent. Next person in favor of the bill. Now we'll move to opponents.
Good afternoon, Vice Chair DeVore and members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T. I'm appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association as their registered lobbyists in opposition to the bill. The bill would make it a crime for a person to record either video or audio within 10 feet of while that officer is engaged in duty. That's what the bill does. The example, respectfully, that Sheriff Wagner gave about a person shoving an object 1 or 2 feet in an officer's face when they're trying to arrest somebody is a crime already. That is obstructing already. If you look at the bill itself, it replicates the current statutory language, and it's on page 2, lines 5 through 7. If any person, by using or threatening to use violence, force, physical interference, or obstacle, intentionally obstructs, impairs, or hinders a law enforcement officer, that's obstruction of peace officer. That's already a crime. Many people who support these bills talk about instances in which officers are spit on, they have something shoved in their face, they're interfered with. That's criminal. This would add more. This would prohibit somebody from recording, not just with a phone, but audio. So for instance, an officer comes to my door, my Ring camera is recording everything that's happening. I'm within 10 feet of that officer. Presumably he's actively engaged or she is actively engaged in their job because they're doing their duties. I'm committing a law violation under this bill. Similarly, many trucking companies and so on have video and audio recording in the cab. If somebody stops in a traffic stop, that's recording. You're within 10 feet of the officer. That's a violation. The courts are clear, and they have been uniform across the country, that people have a right to observe peace officers while they're on duty, and they have a right to record. I passed out my testimony. Nebraska's in the 8th Circuit for the federal courts. There's an 8th Circuit case, Chestnut versus Wallace, in which dealt with a bystander who was arrested by observing police arrest somebody else. And it dealt with a qualified immunity defense that the officer was trying to assert. But this Court of Appeals discussed citizens' rights to observe and record. And they did note that every circuit court to have considered the question of whether a person has a right to record police activity in public has held that they do. So for policy reasons, and really frankly, because this bill is unconstitutional, we urge the committee to not advance it. I'll answer any questions if anyone has any.
Are there questions from the committee? Senator Blood.
Thank you, Vice Chair DeVore. So, Spike, I had trouble hearing you. Why is this not constitutional?
The courts have been clear that people have a right to observe and record police while they're on duty.
Right.
Full stop. You don't have any right to interfere with an arrest. You don't have any right to distract an officer who's trying to do their job. You don't have a right to intervene and bother the cops when they're trying to do their thing. But if you want to record or observe them, the courts are clear you have that right. You can't be arrested for that, and so on.
Right. Thank you.
Other questions, Senator DeKay?
Thank you. And that's a statute that the 10-foot barrier, that's a distance you have to be away.
I haven't looked at all the scenarios in which the courts have said that you have a right. They come up in a variety of different issues. Sometimes people are prosecuted for resisting arrest or obstructing a peace officer or some similar thing. And maybe some of those laws had a 10-foot barrier. A lot of them come up, a lot of the cases discuss instances in which someone is arrested, detained, but not charged with anything. So there's not any kind of criminal case going on, but they sue the police department or sue the peace officer. The officer then claims qualified immunity, and there's a discussion of whether the officer was operating within the scope of their authority by arresting somebody. With respect to the 10 feet, I'd argue that's just an arbitrary limit. In other words, I think you can probably commit the crime of obstructing a peace officer from 20, 30 feet away by shouting, having a PA system, something that interferes with that arrest. And I understand what Senator Lowe is trying to do to accommodate some sort of middle ground, but I think the 10 feet is really just kind of arbitrary.
That was going to be my question, what the distance would be or what circumstances would come into play that could possibly distract a police officer to turn for a second and make that whole situation go south.
I wish I would have brought the case, but there's a case that our Supreme Court affirmed a conviction for somebody for either obstructing a peace officer or interfering with a peace officer that happened in downtown Lincoln. The downtown Lincoln police, the Lincoln police were doing a DUI investigation with somebody, and it was right during bar close. And so, of course, you can imagine people walking on the sidewalk, and some guy was hollering and distracting the officer, and then they were charged with it. And I don't know the facts specifically, but I assume it was more than 10 feet away.
Thank you.
Thank you, Senator Decay. Other questions? I don't see any. Next opponent.
Good afternoon. My name is Corby Gilbertson. It's spelled Korby, Gilbertson, appearing today as a registered lobbyist on behalf of Media of Nebraska Incorporated in opposition to LB 1185. I won't try to repeat a lot of what Spike said, but I will bring up that there was a very similar piece of legislation that was passed in Arizona. Only that piece of legislation was 8 feet, not 10, and it was thrown out for being unconstitutional. A restriction on First Amendment rights to observe. If you want to know more about other cases, I can go into those as well. But one of the things that we talked about, and I think Spike kind of touched on this, but if you had a circumstance where someone was pulled over in an automobile and the passenger wanted to record, they would be obviously less than 10 feet away. The problem with this is they need to then, as Sheriff Wagner said, they need to move so that they would be more than 10 feet away. My observation is police officers don't usually like it when someone gets out of the car during a traffic stop. So that might lead to other problems. Sheriff Wagner also brought up the fact, and I think he said that body-worn cameras have been invaluable in clearing officers of wrongdoing, and that they like having those recordings. The problem with that is they are not public records. So the public doesn't have access to them. And even if they're usually referred to as an investigative record, and even if the case has gone through the court system, they still do not release those because they still say they're part of the investigative record. So I think that's fine to argue that, but only if they would be available to both sides. And with that, I'd be happy to answer any questions.
All right, are there any questions from the committee? I don't see any. Thank you
Thank
for
you.
being here. Our next opponent. Anyone else in opposition to the bill? Let's go with our first neutral testifier. Anyone in the neutral capacity? Seeing none, I'll announce for the record that there were 7 letters, 1 in support and 6 in opposition. Senator Lowe, for your close. Whenever you're ready.
Senator Wayne said he was coming back from my close. I'm going to wait. No. What an honor this is to have my last bill before the Judiciary Committee. I remember Senator Chambers berating me every time I came in here and sat down. I want to thank the testifiers that came in, Sheriff Wagner, others that came in support but didn't speak. I didn't want to belabor this today. There were many law officers that wanted to come and speak in favor of this bill. This is not just for the interest of the police officers. It's also for the interest of the individuals that may be interacting with the police officer. They become nervous when a camera's shoved in their face and they want to know why they're there. Why is it happening? You know, our media used to be the ones with the cameras, and they looked like the cameras that are sitting over here. They're not these all-powerful little black boxes that we carry with us. Everybody's got a camera, and they all want to record what's going on. And sometimes it needs to be recorded. They want to make sure everything is done right, or they want to catch a slip up. somewhere, whether it is the individual that's getting nervous because they're being recorded, or because I'm talking very slow on your account. I didn't want you to miss this,
I didn't. I wanted to be here very close.
but I feel sorry for the people behind me and the last bill introducer also. But it's our law enforcement officers have a tough enough job the way it is, without individuals interfering. And the wingspan of a man is 6 feet. So something just outside that seems reasonable to me for somebody to stand back as the law enforcement officer is having an interaction with this individual. And that's why we came up with 10 feet. And so you don't know what's happening in people's minds. And so that's why I brought this bill. We have law enforcement officers that are being harassed by people constantly. Not only are they videoing and taking pictures of the officer, they're also doing it of their families. And it's I don't care if somebody is attacking me in my position, but it's not nice when somebody is attacking my family.
Senator Black.
Thank you, Chair Wayne. So for clarification, you're saying that this bill should also, it also applies to their families, but that's already a crime.
But it doesn't apply to that family. I'm saying that it's happening now, and people are getting more and more bold as they're doing things.
Okay, so in closing, when you were saying that, you weren't referring to the bill.
No, I wasn't referring to the bill.
Okay, thank you.
Any other questions? Senator McKinney.
Thank you, Chair Wayne. Thank you, Senator Lowe. I know you had mentioned that, law enforcement officers are being harassed and they feel uncomfortable with individuals recording them. And I think part of the reason people began to record law enforcement officers, part of the reason was because law enforcement is hesitant to release body cam footage. And at one time, there was no body cam footage. So would you be open to making body cam footage more public or public?
The law enforcement officers that I spoke to were not uncomfortable with being recorded. They think it's okay to be recorded. They want to be held responsible. The uncomfortable people are those being interacting with the law enforcement officers. And what could be just a normal stop could escalate into something more serious just because the recording.
Oh. But even to take that away, would you be open to making body cam footage public?
I think that's a new bill and maybe should be discussed next year.
Okay. Thank you.
Any other questions from the committee? Seeing none, we have 7 letters. Already did that. One in support, 6 in opposition, and I'm just going to take time because you are a classmate of mine that in my community, we talk about giving people flowers. And so it is the last committee day for you and our last day that we'll be in committee. Will you give that to Senator Lowe? So I wanted to give you your flowers.
All around today.
I wanted to give you your flowers personally because although I think you've only voted for 2 bills in the 8 years of mine, here's what I would say is you were always honest. You've always been logical. And when you can't get to a point, you just tell me you can't get there. And I think that is lost among many of our colleagues that just have an honest dialogue. And I appreciate the evenings at Billy's and talking through things and your perspective because you challenged me to be a better senator. And hopefully I challenge you to be a better senator. But the open and honest conversation and why you can or can't get there has always been helpful. And it made me be, I think, a better person on the floor. So I wanted to give your last committee hearing and say thank you for being there from day one, from Bellevue, when we first met over at Offutt Air Force Base, doing a shot of water. Yeah, it was just a shot of water. Don't worry about it. We didn't have any alcohol that night. But no, seriously, you are a gentleman. You've been a scholar, and you've represented your community very well. So thank you for being here, and thank you for ending your last day with me.
It's been an honor serving with you, Senator Wayne, and Senator Blood. These 8 years drug on at times, but they went really quickly this last year. So thank you very much for everything you've done, and both of you represent your districts very well. So thank you.
And that'll close the hearing on 1185. I have to go back in revenue because my bill's still up. So,
That will open the hearing then on LB 1224 and Senator Jen Day. Senator Day, you are welcome. I was trying to take as much time. Yes. Welcome to open. Welcome to your Judiciary Committee.
Thank you. Good afternoon, Vice Chairwoman DeBoer and members of the Judiciary Committee. My name is Jen Day, that's Jenday, and I represent Legislative District 49 in Sarpy County. Today, I'm here to introduce LB 1224, which would make it illegal to use a tracking device or application on another person without their consent. The idea for this legislation came after hearing the story of an Omaha woman who found out that she was being tracked on her phone and also through the use of an AirTag snuck into the bed of her truck by her estranged husband. Although her ex was arrested for stalking and then had charges reduced to disturbing the peace, both sets of charges were dropped because this specific act does not meet Nebraska's stalking statutory requirements of an intent to intimidate or harass. Unfortunately, this is not an isolated incident. Both in Nebraska and nationwide, this is disturbingly common. Last year, there was a class action lawsuit filed against Apple with 37 direct victims of AirTag stalking in the case. And additionally, following the murder of an Ohio woman by her ex-boyfriend, investigators found a tracking device attached to her car. This specific case prompted an illegal use of tracking device bill, which is working its way through the Ohio State Legislature and recently unanimously passed their state Senate. In addition to Ohio, 19 other states, including Michigan, Illinois, and Virginia, have moved to ban non-consensual electronic tracking. The issue right now is that in a number of states, including Nebraska, stalking laws involve an intent to intimidate, which does not exist in this situation. Much to the contrary, what makes this situation so disturbing is the victim often has no idea they're being tracked. As a result, there's a huge gap right now, and these cases are unable to be prosecuted. This was the case in Omaha, where the Douglas County Attorney's Office concluded that secretly putting an AirTag on someone's phone wasn't a violation of any specific law. I think we can all agree that digitally tracking someone, whether a partner, stranger, or acquaintance, without their knowledge is invasive, grotesque, and something that would already be illegal if the technology existed when we wrote our state stalking laws. Simply put, we have to evolve our laws to match when technology is being used in a malicious manner. Since 2016, the Department of Justice has reported that twice as many stalking victims are now targeted using technology compared to traditional methods. To address this, LB 1224 creates a penalty for installing a mobile tracking device on another person's property without their consent. The bill is written in a manner that would apply to trackers like AirTags or installing a tracking app on someone's phone. The penalty for a first offense would be a Class 1 misdemeanor. A second offense prior to stalking conviction, or an offense while the victim had a protection order against the offender, would raise the penalty to a Class 3A felony. I also want to highlight that this bill has a number of exclusions. Our goal when we wrote LB 1224 was to prohibit the specific act of digitally stalking someone without their knowledge with a tracking device. However, there are a number of reasons you could use these devices in good faith. For example, a business putting a tracking device on one of their vehicles, legal guardians of at-risk adults, parents monitoring where their children are, and it is not our intention to legislate these situations. Our focus is on the idea that it should be illegal to use these digital tracking devices to stalk someone, and the exclusions were necessary to create this narrow focus. Before I conclude, I would like to highlight one amendment we're recommending, AM 2721. This clarifies language that allows businesses to put a tracking device on vehicles they own and aligns with our scope of the bill. We don't want to touch the status of any other circumstances except for these cases where you have people using devices in a clandestine manner to track and stalk people without their permission. LB 1224 presents a critical step forward in addressing digital stalking through the unauthorized use of tracking devices. We all agree that Nebraskans have an expectation of privacy, and this bill updates our statutes to close the gap in our legal framework that currently leaves victims vulnerable and unable to seek justice if this is violated in a specific situation. You'll be hearing testimony from the Nebraska County Attorneys Association, Voices for Hope, and the Nebraska Coalition to End Sexual and Domestic Violence. But with that, I am happy to try to answer any questions.
Are there questions from the committee? Senator Blood?
Thank you, Vice Chair DeBoer. Thank you, Senator Day, for bringing this important bill forward. I got a question for you, though.
Sure.
So you and I are both aware of some of, I'm going to use this as an example. This is something that you and I can relate to. Are aware of some people utilizing tracking methods for dirty campaigning.
Right.
So these same methods can be used on these victims. So we can take these mobile tracking devices off of vehicles and make it illegal, as we certainly should. But then we still have GeoFinder and Find Data Now and Spokio and MSpy. There's like 10 others. Those are the ones I can think of right now, where if I've got your phone number, I can find you anywhere. So are we playing whack-a-mole, or do we need to broaden what we can and can't do?
I think that's a good question. And it's something that I think we definitely need to at least start a conversation on, because it's a serious issue, whichever method is being used. And I think that there's always has to be a balance between making sure that we're protecting individual liberties,
Right.
while also making sure that we're protecting potential victims in any situation. So obviously this bill would not apply to those other situations. And
Which, if I were,
right, it would
If I
be
was going to
difficult
harass
to
somebody, I would just
legislate
find a
that,
different
yes.
and this would be cheaper.
Yes, right. But I think that, this is the first time we've even talked about any kind of digital stalking in Nebraska. So we are essentially today hoping to at least start a conversation, and whatever that turns into in the future, we would like to at least get to work on doing some kind of protection for
It's
folks.
really unfortunate that technology has made it easier
Right,
for people to violate people's privacy and
exactly.
to harass victims.
Yes, agreed.
And we can pass bill after bill after bill.
Right. And there will always be technology evolving faster than we can produce legislation, right? We know that. But we can't continue to just do nothing about it as technology evolves, because I feel like we're already behind in terms of how technology has adapted to make it easier to stalk someone and then proceed to victimize them through violence of some kind. And so, yes, there are other ways that people can access someone's location. But I hope that at some point we can start doing something about it with legislation. Whether that's one thing or all the things is
It could be-
yet to be seen.
Oh, I'm sorry, it can be done to protect us as well. I used geotags when someone kept stealing my signs, and we were able to track it back to
Yes.
their house when they stole them. So
Right.
it can be used for good
Yeah,
things too.
for good as well, of course.
Thanks.
Yep.
Other questions from the committee? Senator Bosin?
Thank you for bringing this bill. Is this legislation mirrored after another state's legislation?
Ohio, yes.
The reason I ask, if I'm looking at page 6, line 11, subsection D says the offender has a history of violence toward the victim. And maybe this is a conversation somebody after you or you and I can have at another time.
Yeah.
Does that require a conviction, or does that mean, a lot of times we have to have a prior conviction before we can do an enhancement, which this is, because it goes to a 3A felony. And so if that is your intent, then I just worry that a prosecutor may come in and say, well, it's all outlined in their protection order. Is that enough to show a history of
Right.
violence, or is that not
I think
enough?
that's a great question, and I don't know the answer to that, but I'm
Okay,
happy to
fair
figure
enough.
that out.
I just wondered if that section came from another state who
We
has
did- yes,
found
we-
that's enough.
And yeah, I'm not sure
Okay.
if that's exactly what the difference is between Nebraska and Ohio.
Okay.
But we did get this from some Ohio legislation, and I'm happy to figure that out.
Okay,
Yep.
thank you.
Thank you, Senator Bosin. Other questions? Senator Day, I have one. Is
Yes.
there, since this kind of got triggered by what Senator Blood was asking you. Is there a way we could, like, modify or amend our stalking statute as it is now to incorporate like more of these things? I don't know. That's just something I didn't know if you guys thought about or.
I'm not sure. That might be a good question for somebody behind me
Okay,
who has
sorry
a
about
better
that.
understanding of the law than I do.
Yes.
Yeah.
All right. Any other questions? Okay. Thank you,
Thank you.
Senator Day. Will you be here to close?
Yes.
All right. First proponent. Welcome.
Thank you. Good afternoon. My name is Rachel Bolton, RACHELBOLTON. I'm testifying on behalf of the Nebraska County Attorneys Association in favor of LB 1224. I currently serve as a deputy county attorney at the Sarpy County Attorney's Office with a focus on domestic violence. I prosecute any crime where the defendant and the victim meet the definition of intimate partners. I'm testifying in support of LB 1224 today because I have personal experience with victims of the actions of that this bill would criminalize, individuals who are being tracked without their consent. This is criminal behavior, but it is not a crime in Nebraska. My experience has been primarily with individuals who are also the named victims in other crimes, who have been or are being tracked by their abuser. One instance came to my attention when a victim of a domestic assault who began to share the other ways that she had been abused by the defendant. She casually mentioned to me that she had found out he had been tracking her without her knowledge. Another one came in after the victim had taken her vehicle into a car shop and the auto mechanic had located a tracker on her vehicle. An investigation was conducted and a request for a warrant was submitted for a stalking charge, but after reviewing the investigator's warrant request, I did not believe that I had the facts necessary to support a stalking charge, and I was unable to prosecute under any other current laws. The sentencing provisions that are proposed by LB 1224 mirror the sentencing provisions of the stalking statute, which makes this offense a Class 1 misdemeanor, the same classification as a third-degree domestic assault, violation of a domestic abuse protection order. I believe that this appropriately reflects the severity of this behavior and the level of victimizations that these victims experience. The provisions also allow for the enhancement of the classification for various reasons. These enhancement provisions allow for the offense to be classified as a 3A felony, the same classification as a subsequent stalking offense, subsequent domestic assault, or subsequent violation of a domestic abuse protection order. The protection order enhancement provision is particularly important to me, as protection orders presently do not prohibit the tracking of a protected party. So long as the tracker does not communicate with the victim, the respondent to a protection order could, in theory, place a tracker on the victim's vehicle and not be in violation of that protection order. We live in a world where technology makes our lives better and also in some ways worse. Using an app to track your teenagers or your spouse or your friends and family is accepted. It is a piece of technology that many people benefit from in their daily lives. But like most technology, it can be abused, and it is being abused. There are people who are tracking others without their consent, and it is not currently a crime in Nebraska, but it absolutely should be. I ask that you vote in favor of LB 1224, and I thank you for your time. I would welcome your questions.
Are there any questions from the committee? Senator Bozen.
Thank you. Thank you for being here. So you heard the questions that I asked
Yes.
Senator Day about the language specifically referring to a history. Do you see where I was going with that?
Yes, ma'am.
Okay. Can you tell me how you think this bill covers that, or do we need to tighten that language up a little bit?
I actually had the same thought that you did. I think that tightening the language would be a good idea. I think if the intent is for there to be a requirement of a previous conviction of violence with the same victim,
Or
that
even disturbing the peace of the same victim, or
you could expand language to any crime that lists this, has the same named victim listed.
Right.
Which I think the idea of disturbing the peace is beneficial because many crimes do get pled down to that, but they are still listed as the victim of that type of crime.
have you prosecuted specifically stalking charges?
Yes, ma'am.
Okay, so the example that Senator Day gave of an individual who found a tracking device, I assume is the same that you're referring to in paragraph 3 of yours. What did you think was missing? Because the putting on of a tracking device on someone, I guess we look at that from both the perspective of the victim and the intent of the defendant, right?
Yep.
What other purpose would they have but to intimidate and harass them? I mean, is there case law that says that wasn't enough?
No, but the way that the stalking statute is written, it's actually a cluster of statutes. It's harassment and stalking, and they're all built together, and then there's the definitions in there. So the definition of harassment is a course of conduct, which can be in a short period of time or a long period of time, but it has to be a course of conduct that, in my opinion, the victim has to know that that course of conduct is occurring. So if in theory, if someone is tracking somebody and they don't know, you can't be intimidated or threatened if you don't know something is happening.
Well, arguably, you're upset every day thereafter that you know, right? I mean,
But then the course of conduct is done.
and I'm not arguing with you.
No,
I'm just
that's
trying to
okay.
think, to me, if I had a tracker on my car in December of 2013, or 2023, but I didn't find out about it till January of 2024. But now that I know, and I'm thinking back to the times that I drove to some place in December, that I wouldn't have wanted that person to know I went to, I'm having to relive all of those intimidation moments even after the fact. Now, maybe that's too far attenuated, but I share the frustration that put you in when you knew that was certainly stalking. Just
Absolutely. And I think that thinking that it is the same thing as stalking is very common. I think that primarily the intent of the defendant and then the subjective intimidation, terrify, or threaten of the victim are the two separate parts that I struggle with on the tracking. The intent of the defendant, intent is always very difficult to prove. There are many reasons someone could say that they intended to track somebody that don't involve terrifying, threatening, or intimidating. Placing a tracker on a vehicle, for instance, there are a million different excuses someone could give for that. So that intent part of it is very difficult when it comes to tracking.
fair enough. Thank you very much.
Other questions from the committee? Senator McKinney.
Thank you, Senator DeBoer. I guess, is it possible for somebody to install something and you never find it?
I suppose.
Okay. So what about if somebody shares, like, let's say you're married to somebody, y'all follow each other on social media or some type of app somewhere, y'all get a divorce, y'all don't like each other, and you get a protection order, but for whatever reason, your location is still shared on social media. Would that violate this?
Yeah, yes, and it's actually addressed in the statute itself. There's language that indicates that if two people are spouses and one files for the divorce, that constitutes revoking consent to be tracked.
But if we follow each other on social media and you don't unfollow me or unfriend me, how does that make sense? You get where I'm getting at here?
Are you tracking someone through social media?
No, but you're sharing your location.
Oh, so if you post and choose to share your location?
But we got a divorce and you have a restraining order on your ex-husband. But for whatever reason, we're still somehow connected on social media. Because there's a bunch of apps where locations are shared. And I don't think people realize at times you're sharing your location. Would that person be in violation unintentionally?
I don't know that I'm following your question. I'm so sorry.
What I'm asking is it possible for somebody to unintentionally violate this law by being married to somebody? During the marriage, we follow each other on all these social media sites. Then we get a divorce, the person gets a restraining order. We're still following each other. Would that husband or that wife still be in violation?
And by following each other, you mean that you're sharing locations in some way?
One of the two is still sharing the location, and we're still able to see each other's location. Is that a violation? Because I didn't unfriend you, or that person didn't unfriend another person.
I don't think being friends on social media would be a violation. I'm not sure
But you're
about
still,
the tracking.
but I'm still able to see that you're at Walmart for whatever reason.
Because that's the profession I have posted? I'm so sorry, sir.
Like, for example, on Snapchat,
Okay,
you could directly see that I'm in this room possibly if I want to share my location,
sure, okay.
or that I'm in this building.
So I think this, if I recall correctly, I think the statute language requires that the person either places or installs in some way a tracking device or app on the person's information.
But it's also the consenting person who was given. But it's another part where it says for the purposes of this section, the person. But then it's like it gets kind of murky about the marriage portions of this. So I don't know, like the consenting person and the person whom consent was given are married. One of them files an action for divorce, annulment, or separate maintenance. I don't know, maybe I'm just reading this wrong, but I don't know if it's clear that if two people get a divorce, but they were following each other on social media, and one of them is sharing a location, could you indirectly violate the law?
I think if the choice to share the location is with the person who's the victim, then no, I don't think so.
But it says the person revokes the consent if the marriage takes place.
Correct, the consent.
That's my point. If you revoke the consent if marriage takes place, and we never unfollow each other on social media, am I in violation?
I would think not, because the consent is given by the person who is sharing their location. So if I am married to somebody and I have shared my location with them, and I had the ability to do that, that was my choice, I did that, they didn't install something, they didn't
But
place something on me, and then I continue to not, to allow that consent, I think that is.
But how could the law say, once you file for divorce, you revoke the consent, but you also say that I'm still giving consent? I think it's contradictory.
I mean, I have read through the statute. I don't think it is, but if you think it is, I think it's possible that two people could disagree, and maybe it does need to be looked at closer.
Yeah, all right,
But I don't find it as confusing, I guess.
all right, thank you.
Thank you, Senator McKinney. Other questions from the committee? So can I ask you that the deficiency in the stalking statute currently is that there isn't that it doesn't meet the element of you have to feel threat, the victim has to have knowledge because they have to have feelings about it. Is that the problem?
That's one of the problems, and then the intent behind it as well.
The intent being the stalker's intent to,
So
under the current statute, I just don't know.
no, that's okay. So to meet the stalking statute, the stalker has to have an intent to threaten, terrify, or intimidate.
Got it.
Which is very difficult to prove in a tracking case. And then the victim of the tracker has to actually feel threatened, terrified, or
Why-
intimidated, which is also difficult.
Why is that difficult to prove? If you put something on someone, they're gonna have feelings about it. So I'm not trying to.
No, that's okay.
I just think maybe there's a way to say if there's a stalking statute as it is, because I'm thinking about what Senator Blood was talking about with all these other sites, that you don't actually put something on someone, but you're following them through something, these things.
Sure.
And so, first of all, I think that those sites, I didn't know they existed. That terrifies me. So is there a reason why the stalking statute requires this knowledge on the part of the person who is stalked?
I guess I would think that the reason would be that in order to, just the basis behind that being a crime would be the person feels unsafe or threatened or intimidated by some course of conduct that another person is doing to them or doing in their proximity that makes them feel that way.
Is it enough for somebody, so it's not, so if I just follow Senator Blood around, but I'm not intimidating or whatever, and she doesn't feel intimidated, is that stalking?
No.
Okay. She has to actually feel intimidated by me following her, which she would be annoyed.
I do.
She might be annoyed, but she might, okay. I think I understand. Thank you. Senator Blood has a question now.
Thank you, Vice Chair DeVore. So to further complicate this issue, so first of all, I like the bill, and I didn't want to say differently. But I do, that is my number one concern, is that if we are truly trying to prevent this from happening, is there a way that we can include, and I mean, I know there's always going to be something technology-wise, but I literally during a campaign had a spouse of my opponent stalk me. And that's how I found out that it was so easy. I mean, I could easily probably write down 20 different sites that if I go to them and I know your cell phone number, I can find you in the blink of an eye. And I can come and harass you because I'm always there, right? And I would feel threatened or feeling like punching that person in the face, whatever day it was, right? Which I would not, of course, do. I would just feel that way. So how, I mean, this technology that we're talking about is old technology, right? I mean, it's old technology.
Yes.
Decades old. How do we combine the two, or is it just not something that's going to be beneficial to this bill if we do that?
I think I've been thinking about it since you asked Senator Day your question. I think when someone tracks with the sites that you're talking about, which is terrifying, I don't know that this bill addresses that, and I'm not saying that it's not possible to address it in a future bill or in this bill even itself.
I agree the bill doesn't address it. That's why I'm asking you. We're able to do amendments in committee on things like that. That's why I'm asking.
So I think that would be extraordinarily difficult to prove unless you, as the victim of that particular form of tracking, were aware of being tracked in that way. And for some reason or another, either someone keeps showing up at the same place where you are or something like that, you would have to become aware that you were being tracked that way in order to file a report and start having that investigated. Whereas this bill specifically addresses instances where people go for long periods of time without knowing that they're being tracked in the first place. The situation that you're describing, I think, would neatly fit into the stalking and harassment statute. And I think that part, that's what I would charge that behavior under as a prosecutor, as opposed to this addresses something specific that cannot fit neatly into that statute.
So you're talking, this is more of a latent situation as opposed to a more obvious immediate situation.
Can you repeat that? I'm sorry.
This is more of a latent situation as opposed to a more immediate and obvious situation.
Correct, because I think the immediate and obvious is already covered by the stalking statute, whereas this is kind of plugging the hole in the stalking statute left by the fact that someone can be tracked without their knowledge. I don't think it's fair that someone could be tracked without their knowledge just with their phone number either, but without addressing the legality of that type of technology, I guess that would be, like I said, extraordinarily hard to prove unless you were also meeting the behavior that would fall under the stalking statute.
Okay, thank you.
Any other questions? That was extraordinarily helpful to my question, so thank you.
Thank you so much for your time.
Next proponent. Welcome.
Welcome. Thank you. Good afternoon. My name is Natalie Roberts Day, NATALIE-ROBERTS-DAY, and I'm the Executive Director at Voices of Hope here in Lincoln. Voices of Hope works with individuals and families who are impacted by domestic violence, sexual assault, human trafficking, and other forms of abuse, including stalking. And daily, we witness the impact of technology-facilitated stalking, often from an intimate partner. Last year, we worked with 2,766 individuals And in so many cases, technology is being used to maintain power and control over the victim. Abusers exert control in many ways, yet the unique impact of being constantly monitored cannot be overstated. Abusers will track where and when a client is trying to access support, and closing off and compromising support systems, including family and friends, healthcare providers, and advocates, isolating them and making it incredibly difficult to access help. When survivors do flee, it is the most dangerous time. 75% of domestic violence-related homicides occur upon separation, and there's a 75% increase of violence upon separation for at least 2 years following. And tracking makes it harder to get away and to stay away. Advocates at Voices are constantly needing to revise and become more creative with the questions that we ask about safety planning when we're trying to bring clients in to access services or to help them relocate, because as you guys have identified, the target is always moving. However, this would do a lot to help just make sure that there is some kind of system in place when we see this. And as I said, we see this on a daily basis. Our advocates are constantly trying to learn how to keep up with all of these apps and constantly trying to figure out how to close these loopholes. But we also know that frequently it's not enough. It's very frequent that we hear survivors share, I fled to another community and he found me again and nobody will help me. They're saying there is nothing they can do. Proving intent is very difficult, as we have highlighted. And oftentimes survivors will decide that it is safer to just let the abuser back into their lives, to know what he knows, rather to live with the uncertainty and fear. Non-consensual tracking is an intentional and deliberate control tactic. And when abusers face no consequences for such violations, it emboldens and encourages them to continue. This bill would help shift attitudes that normalize tactics to maintain control through fear, threats, and restrictions on freedom, and would create opportunities to hold perpetrators accountable and increase safety for our survivors. Thank you.
Are there any questions from the committee? Senator Bosset?
Thank you. Good to see you. Right now, when a victim comes in for services and assistance, if they present with issues of tracking on their phone, are there a lot of times that Voices of Hope and other victim advocacy groups are faced with either funding a different cell phone for that individual or subjecting the victim to ongoing harassment?
Yes, so that's something that is a huge part of our client resources, is trying to connect people with a safe cell phone device. But again, there's not any kind of recourse when we know that someone is tracking that way. It's just a Band-Aid for what's happening. And what was the second part of your question? I apologize.
Well, it's a cost for you as doing service, and you're happy to do it. I know that, but the reality is that's a significant expense when a victim comes in, and if you can't accomplish that or accommodate that, you're basically sending them out the door, telling them, sorry, you have to just keep your cell phone and be tracked.
It is, and sometimes, if someone is trying to flee that partner and that partner is so controlling, then sometimes having changing a cell phone number or things like that can escalate that violence. And so it's very difficult to navigate these situations. But again, right now, our only tool when someone is saying, I'm being stalked, I'm being, my partner is constantly following and tracking me through my technology, or my ex-partner in particular is constantly following me through that technology. Our only recourse is to say, here is a stalking log, let's try and create a record so that we can prove that intent. And that puts further burden on that survivor at a time when they're just trying to meet their basic needs and create safety.
Thank you.
Thank you, Senator Bosset. Other questions? I don't see any. Thank you for being here. Take our next proponent. Welcome.
Hi, thank you. Dear committee members and Senator Jen Day, my name is Sarah Niazi, spelled Sahraniazi. Thank you very much for allowing me to speak today about this important bill, LB 1224. This bill draws much emotion from me, for my story, although it may seem harmless to the layperson, has left me deeply wounded, emotionally scarred, and most of all grappling with how to be a positive and unyielding role model as a physician in the community, and especially for my 3 young children. My stalker was someone I knew for 17 years. I was completely naive to think that this person would not go to the depths of dark behavior that he reached. I allowed this stalker access to my home and vehicle on multiple occasions, despite separation, filing for divorce, and him moving out of the home. I am still troubled that I was naive enough to allow this, that I somehow was weak and unable to prevent it. Over the course of 6 months in 2021, I would receive unsettling and terrifying text messages, mainly from this person's cell phone, but sometimes from an anonymous landline as well. These texts would detail my whereabouts and threaten me depending on my location and presumed activities. I tried incredibly hard to figure out how my stalker was tracking me. I thought I could ask him politely to stop harassing me, for surely this person I knew for 17 years would not want to cause me harm. After an exhausting 6 months of disturbing text messages and filing 2 police reports, I took my vehicle to the Anderson Ford dealership in June of 2021 and begged them to help me find how the stalker was tracking me. Within 10 minutes, the mechanics had found a mobile GPS tracking device underneath the passenger seat of my vehicle. I was incredibly relieved and called the police. However, I was told there was nothing they could do. I also filed 2 harassment restraints, but the judge overseeing my divorce dismissed them. I am a strong proponent of limiting conduct related to mobile tracking devices because stalking has had a very adverse effect on me and has on millions of others. An estimated 13.5 million Americans are stalked in a year. And as Senator Day has also mentioned, more than twice as many victims are stalked using technology versus not. The impact of stalking on victims is not a surprise. The fear of not knowing what will happen next, the fear that there is no end in sight, the fear that this person will harm you possibly lethally is terrifying. Perhaps the biggest fear I felt during this period and after is that there was no one to help me. For I knew intimate partner stalkers are the most likely to approach, threaten, and harm their victims. I remember phone calls I had made to my lawyers at the time. I was physically sick to my stomach and sobbing, asking them how to not let this person kill me, telling them that stalking behavior is incredibly frightening and an indicator of further violence to come. But I was just laughed off and told to become more level-headed. If there was a bill passed that made it easier to stop stalking behavior, surely victims would experience less trauma, less anxiety, and more trust in our system. I am strongly urging you and asking you from my heart to please help stop stalking practices, especially when it comes to mobile tracking devices. I believe as Nebraskans, we should be able to come together and stand tall hand in hand to show victims of these unethical acts that they are not alone. And even more to say to the aggressors that their behavior is not okay and will not be tolerated. Thank you.
Thank you for your testimony. Are there questions from the committee? I don't see any. Thank you for being here. Next proponent. Welcome.
Thank you, Acting Chair, members of the committee. I want to thank Senator Day for introducing this very important legislation. I can say that as we speak, there are individuals in our state who own a phone, purchased a phone, pay the expensive bill every month, and this phone is being managed by somebody who they have a prior domestic violence protection order against. This is not the only thing that people like this have experienced. They've also experienced things where their email is being forwarded, where their work files are being deleted. The financial accounts are being taken over and they don't have access to their own financial accounts and they have limited access to money and have experienced many forms of abuse. So again, I thank you for bringing this legislation to the committee and I ask that you advance it. It's really important for a lot of people because no one should have to be forced to live like this because many people are forced to just accept this right now. Thank you.
Thank you. Are there any questions? Oh, I'm sorry, ma'am. We didn't get your spelling. Sorry. Could you spell your name for us?
I'm sorry, that was at the top. Sheila Court, Sheila Korth.
Thank you so much. Okay.
Thank you.
We'll take our next proponent. Welcome.
Good afternoon.
Vice Chair DeBoer, members of the Judiciary Committee. My name is Kristen McTaggart, CHRISTON, MACTAGGART. I'm the Executive Director of the Nebraska Coalition to End Sexual and Domestic Violence. We're testifying in support of LB 1224 on behalf of our network of 20 domestic and sexual violence, trafficking, stalking programs that support survivors in all 93 counties. We believe this bill honors the multitude of ways that stalking shows up in our work, particularly in intimate partner violence and trafficking, but also in other types of sexual violence. We also know this particular issue is a current gap in our statutes, and we've heard that from numerous survivors, some of whom you've obviously heard from today, and that those statutes just haven't necessarily kept up with technology. Some of the things that we have heard from survivors is that they're just trying to maintain safety and that they often just cannot stop this from happening. They're left with no recourse for holding the person harming them accountable, even though it's actually one of the most common methods of the abuse that they're experiencing. About 66% of women report being stalked by an intimate partner, and 76% of women who were murdered by an intimate partner were stalked pretty extensively first. What we see and what we hear from survivors is that it helps offenders understand their patterns, their daily schedules, when they're vulnerable, when they're available, and it ensures that they really cannot ever do anything outside of the knowledge of the person who's harming them. It prevents them from leaving sometimes, it prevents them from living with a life without fear, and it's particularly heightened if they do leave. So that means that sometimes survivors can't keep a new residence that they've moved into a secret because they're being tracked. It means that their former partner shows up when they're out with friends, when they're dating again, and it's particularly present when they utilize children that they may have in common to continue the stalking as well. So we've seen everything from survivors being stalked through tracking mechanisms in children's belongings, like a stuffed animal to a backpack to their phone. And as you heard from Voices of Hope, our advocates and our programs typically safety plan around stalking through technology with every person they work with. I mean, gone are the days of stalkers hiding in bushes, right? They don't need to. Technology makes it easy. And so, again, we just acknowledge that this is a current gap in our statutes and that we're asking for this additional recourse for survivors who are experiencing this. I'm happy to answer any questions that you might have.
Are there any questions? Don't see any. Thank you for being here. Next proponent. Is there any opponents?
Good afternoon, Vice Chair DeBoer and members of the committee. My name is Spike Eichel, SPIKEEICKHOLT, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorney Association as their registered lobbyists in opposition to the bill. You've got a copy of my written testimony, but I might just respond a little bit to some of the things that were talked about earlier. Generally, both the clients I represent are opposed to adding crimes to our already arguably overburdened criminal code. This is 6 new pages of criminal code, so it could be resolved by simply amending our stalking statute. When we first looked at this bill, we saw this as creating a new crime. If you look at page 3, lines 4 through 14 or 4 through 13, that's the commission, or those are the elements of the crime. The crime is committed if a person knowingly installs a mobile tracking device on another person's property without their consent or without any of the other exceptions applying. That's when the crime is committed. The mobile tracking device does not have to work. The victim doesn't have to even know they're being tracked. The crime is committed then. I think Senator Bosin alluded to it before. I don't mean to second guess the prosecutor's decision not to charge it. I don't know all the facts, but our stalking statute provides that if a person does something with intent to harass or intimidate somebody, that's stalking. If a person finds out that they've been tracked for a while, that's intimidating. That's harassing to them. Now, if something needs to be modified on that statute to not require the intent to be on the person doing it with intent to harass, because arguably the defendant might not be intending to harass, he's just intending to follow, then that's one thing. But this would add a whole other crime that is problematic. We have a number of other crimes related to trespass, disturbing this peace, maybe even assault that could apply as well to some of these circumstances. And you kind of saw some of that or heard some of that with some of the testimony earlier. Secondly, if the protection order statutes don't allow for a court to preemptively prohibit a respondent from installing a tracking device or following in some way, but that's a different conversation because that's not necessarily adding a criminal code or something to the criminal code. Finally, Senator Bosma mentioned this earlier on page 6, lines 5 through 11. That is problematic, and I referenced it in the statute. This allows for enhancement beyond a misdemeanor if certain things are shown afterwards. Under our case law, under the U.S. Supreme Court case law for a series of cases, a prior conviction could be used to enhance, but any fact, any factual circumstance needs to be found by a jury and needs to be proven beyond a reasonable doubt. So this offender has a history of violence. That's not necessarily a conviction. So that's problematic right there. And similarly, the factual circumstance of whether the offender had a protection order or was the subject of a protection order is not the same as a prior conviction, because a person can have a protection order against them without having been convicted of a crime at all. So those areas are suspect. I'll answer any questions if anyone has any.
Other questions from the committee? Senator Bosma.
Thank you. So are you going to tell people that if they're your clients, future clients, that if they're tracking someone on their cell phone, they have to plead because that's the intent of the law?
Well, to be honest, I don't know why I wouldn't be stalking now. That's just my take, because like you said, if somebody tracked me, I'm getting tracked by apps and companies. We all are. We got license plate reader systems on the interstate. We're always being tracked. If somebody tracks me, I find out about it, and it's a person I know, it's somebody close to me, somebody that might, I'm a bad example here, but anyway, that is intimidating to me. That's harassing. That disturbs my peace. Those things I would never tell anyone that's fine to do, because my take on it, you're in that whole area of stalking anyway. That's just my take on it.
So my second question, with regard to the language on page 6 that you referred to, the enhancement, we'll call it, is that different than the enhancement we have right now for a subsequent offense, domestic assault?
Yeah, it is. If you look at on page 6, lines 5 and 6, that's similar to the language we have now for domestic assault.
Oh, I thought that's what you were referring to.
No, I was talking about lines 7 through 11.
Okay.
That allows for enhancement if at the time the offender had a protection order against them, not necessarily even from the victim, but just had a protection order against them. That's not a conviction.
So is there nowhere else in criminal statute where being the subject of a protection order doesn't subject you to enhancements?
No, there can be such situations like that, but this is a sentencing enhancement, and those are the circumstances. That's an element of the crime.
But that's an element of the crime here.
Not necessarily. If you look on page 5, lines 29 through 30, it says, except as provided a violation of section 3, and section 3 is the part that I talked about where you install the device. A violation of section 3 is a class 1 misdemeanor unless, and then they list these other things.
Right, but in a criminal complaint, isn't that how your allegations and your elements would list is you did this, you did this, you did this, and you were the subject of a protection order, so the state would have to actually prove that there was a valid and active protection order that had your name as the subject as one of their elements in order to receive the 3A felony.
I suppose they could try to plead it that way, but it seems to be kind of confusing because I'm not sure it's laid out like that in the other enhancement statutes, where the language says the penalty. If you look at section 5 on lines 5 and 6, this is the section that talks about what the penalty is, not necessarily what the elements of the crime are. So I think it could be pled that way. You say, I hadn't really thought about that. When I looked at it, I looked at the elements in section 3. That's what would be reflected in the complaint or the information, depending on what it may be. But I suppose you could just merge both of those sections in the charging document, and as long as the jury were to make that finding, or the person waives jury, the factual findings, then you could. Those prior convictions aren't submitted to the fact finder because the case law says you don't have to. And yeah, I don't want you to. And sometimes you don't want either because it's unnecessary to do it that way.
I'm going to chance it. But I understand. Thank you.
Thank you, Senator Bosma. Other questions from the committee? Mr. Eckel? you heard some of the testimony earlier about situations that folks are in and that the prosecutor as well. What's the remedy? Because obviously we want a remedy for that situation. So what is the current remedy? And then if not, then why isn't this the remedy?
As I kind of said earlier, when my defense attorneys and I were talking about the bills that were introduced, one of the things that some of my members says, well, this is probably stalking already. This is adding another crime. And the concern that we have is that you've got, and you saw it most recently on the UNO overcrowding charge and report, you've got multiple overlapping crimes that are regularly charged. And then when people are convicted of multiple charges, sentences are stacked. And I can talk about that, but that's another conversation. That's a concern that we have. The remedy might be if there's something about the stalking statute that needs to be resolved regarding maybe the mens rea on the defendant's side, or perhaps to modify the element to reflect the feelings of the victim. That might be the better approach.
So if I'm being tracked for the last 5 years and I find out about it, so somebody puts it in my car,
Right.
5 years, that's the element where they've started the tracking.
Right.
I suppose they don't even have to look at it, right? Like I just know it exists, or I don't yet, but I will know that it exists. And they put that in there. Is it upon my discovery that the crime has happened? Or is it when they place it?
I think if you look at section 3, the crime is committed when they place it. And the example that you gave is it's discovered 5 years, you couldn't charge it anyway because you're beyond the statute of limitations.
That's what I'm wondering, if there's a statute of limitations thing. But does that happen with our stalking statute as well?
I don't think so, because the crime of stalking is committed when sort of the victim is aware that they're being.
So wouldn't that be the 5 years later that they become aware? Because you're saying, Senator
Right.
Boslin is outlining that they feel, oh no, they knew where I went all this time, and that's when they have the feelings, right? But if that's when they have the feelings, then do we have a statute of limitations problem? And is that why we can't do it as a stalking statute, or, as part of the stalking statute, because that would be subject to the statute of limitations?
I think and I can't really, it's not fair for me to speak for the earlier testifier, but if I remember the county attorney explaining that they had concerns about charging the stalking statute, not necessarily because of when it was discovered, but because of the elements of what the defendant intended to do, intimidate, threaten, or harm. I think that in your example, it's easy for me to say, I don't know that you necessarily wouldn't be able to get a conviction for stalking, because when it's going to be a she, let's be blunt, when the victim discovers it, it doesn't matter when it was installed. She's been tracked within the 3 years or whatever for a felony, or a year and a half with a misdemeanor to be charged.
Okay, are there other questions? Senator McKinney?
Thank you, Senator DeBoer. Spike, do you think it's possible to unintentionally violate this? I might have just read it wrong, but I was just curious.
Well, if you look at page 3, line 5, the only mens rea, and it's kind of written in the negative, which is even kind of more odd, a person shall not knowingly install a device. So it doesn't even require, the element's not intent, right? It says that you should not do it knowingly. So I don't really know what the state would have to prove. It's difficult for the state to prove a negative. It's kind of odd. Normally, most of our crimes have a mens rea. A person shall not intentionally or knowingly cause bodily injury to domestic, to a victim. This is just kind of weird. So maybe non-intentional. I don't know if you can install an AirTag on. I mean, you might install an AirTag on the device, and during the breakup, somebody takes that device with them, and then you start following them unintentionally, or at least not. I don't know if you can. It's just kind of unclear.
Thank you.
Thank you, Senator McKinney. Other questions? Okay, Mr. Eichholt. Next, opponent. Anyone here to testify in the neutral capacity? As Senator Day is coming up, I will note for the record that LB 1224 had 3 letters, all in support.
I appreciate the committee's questions this afternoon and listening attentively to the testimony today. I think this hearing has helped us clarify a few things. I think in terms of the language that Senator Bosin, you had asked about in my opening, we would be happy to bring an amendment to remove any ambiguous language, page 6, line 7 through 11, that would still allow for the escalation in the place of a previous conviction. And it would remove some of the language that is unclear in terms of needing a conviction or not to escalate what the crime would essentially be. Mr. Eichholt did let me know ahead of time that he was coming and opposed, and interestingly, we are often on the same side of these discussions in terms of enhancements to penalties or creating new crimes. However, we are on the opposite side today. I feel very strongly about issues like this. As a survivor of sexual violence myself, I think that it's extremely important to understand how often these types of things happen and how these instances are being facilitated by technology. As Senator Blood mentioned, this is old technology. We are already behind the curve in terms of legislation to make an attempt to control what's happening here. Additionally, we brought this bill because Douglas County essentially said that they can't prosecute for this right now. So is there a possibility that we could open up the stalking statutes and change that a little bit? We could do that. That's a much larger undertaking than what we're trying to do here today. And so with the county attorneys, we had someone from Sarpy County here as well. They're telling us that there's a gap here that needs to be fixed. And in hearing how often this type of thing happens, even very passively in some of the mom groups that I'm in, like on Facebook and stuff, I've heard women mention, I was digging through my purse and I found an air tag. I don't know where it came from. I don't know who put it in there. It's terrifying. It happens at bars. People will just toss an air tag in someone's purse and they can follow you home. They can do that anyways, but it makes it much easier to be hidden. Having access to these apps, that's not what we're covering here. This is about having an intent and knowingly taking either a physical air tag or some kind of physical technology and putting it in a car or on someone's person to track them, or with intention, finding the person's phone and putting an app on the phone. I know there are apps currently like Snapchat. I only know this because I have a teenager in my house, that you can see someone's location, but you have to willingly share your location with those apps. Whenever you are downloading an app on your own phone, you have to opt in to location sharing, right? This is not covered in this here. We are talking about if I grab my husband's phone and install an app unknowingly to him on his phone, and then I track his location without his consent. That's what we're talking about, not tracking from an app that you have already utilized consent to share your location with. So again, I'm happy to bring any kind of amendment to clean up the language, to be more specific. Whether, in the future, those things would be included in the scope of this type of legislation, that's left up to future legislatures. But right now, I think that this is something that we definitely need to address because we are already behind the curve. It happens very frequently. Prosecutors cannot charge people when it comes to this specific issue, and we have to figure out how we can close that gap. So I'm happy to answer any questions.
Are there any questions from the committee? The one thing I was thinking of as we were going through this, because I think you're right, maybe about the stalking statute, is what if the crime happens when they place it, then you
Right.
might have a statute of limitations issue and you probably have to figure out how to work around that. So just
Yes,
put that on your
exactly.
radar.
Yes. I appreciate that.
Okay. Thanks.
Thank you.
That ends our hearing on LB 1224. And that will begin our hearing on LB 1357. Welcome, Senator McDonnell. Senator McDonnell, is this your last hearing?
This is it.
All right.
Pretty excited. Sure you are too.
Welcome, Senator McDonnell.
Thank you. Senator, you want me to start? Thank you, Senator DeBoer. Thank you, members of the committee. My name is Mike McDonnell, MIKEMCDONNELL, represent Legislative District 5, South Omaha. Legislative Bill 1357 is a crucial piece of legislation that seeks to address a pressing concern in our communities, the issue of unregulated camping on properties owned by the political subdivisions. The inception of LB 1357 is a result of extensive consultation and collaboration discussions with local government officials, law enforcement agencies, social service providers, and community stakeholders. These discussions have illuminated the complexities and challenges posed by unregulated encampments in our urban and suburban areas. Our cities are witnessing an increase in unregulated encampments that not only pose significant public safety and health risk, but also impede the ability of the political subdivision to efficiently and effectively utilize and manage the public properties. These encampments often lack basic sanitary facilities, access to healthcare and secure living conditions, thereby exacerbating the vulnerabilities faced by individuals experiencing homelessness. LB 1357 aims to prohibit camping on certain properties not designated for such use by political subdivisions, thereby encouraging a more organized and humane approach to addressing homelessness. This legislation is not intended to criminalize or personalize individuals' experiences, or penalize individuals experiencing homelessness, and would require clearly marked signage and where camping is prohibited for any violation to occur. Instead, it seeks to ensure that public lands are used appropriately while also highlighting the need for a comprehensive strategy to provide support and services for homeless population. The purpose of this bill is to establish regulation camping areas, remnant of emergency shelters deployed in crisis situations, as a means to address the rising issue of homeless encampments through and thorough and principled approach. These designated areas should be furnished with necessary facilities and services to ensure a secure, clean, and orderly environment for temporary stays. Addressing the challenges effectively requires a comprehensive situation of services, included healthcare, mental health support, and sanitation, as well as facilitating access to traditional or permanent housing, all reflecting best practices in emergency shelter management. The success of the initiative hinges on active engagement from the community in both the planning and the execution of the phases to ensure that the solutions are adapted to the specific needs and realities of the local area. Moreover, this bill extends to the city's regulatory tool currently available to counties, enhancing the uniformity of the approach towards managing public property camping issues. In conclusion, LB 1357 represents a critical step towards creating a more structured, compassionate, and effective framework for managing the challenges associated with unregulated encampments. By adopting a balanced approach that emphasizes both the responsible use of public properties and the provision of essential support services, we can make significant strides addressing homelessness in our community. Also in your handout that you received starts with the state law that currently the statute that talks about the state and the county properties, which this law was mirrored off of for our local municipalities. The idea of posting, communicating, and then enforcing, that is the goal. The idea that also that if you look at these encampments, there's no help in those tents. There's no assistance in those tents. So the individual that is looking for help, we want to make sure we reach out and get that person going the right direction and get the help that they need. At the same time, we want to enforce the idea of where, and this isn't a mandate to the local communities, this is an option. So if a local city council says, well, okay, we'd like to enforce that, we're going to go ahead and put a designated camping area. As I mentioned in my opening, the idea, you've seen some of the FEMA ideas and what they set up for disasters or natural disasters. Something similar to that to make sure that people are getting the help they need, the services are there, but you cannot just have camping throughout the city. It's not going to be productive and it's not safe for our citizens.
Thank you, Senator McDonnell. Are there questions from the committee? Senator McKinney?
Thank you, Senator DeBoer. Thank you, Senator McDonnell. What's the result of a Class 3 misdemeanor?
So Class 3 misdemeanor could be nothing up to 90 days or $500 fine. Class 5 misdemeanor, according to the state law with county and state property, is up to $100 fine.
What do you mean by nothing? What's nothing?
It could be, they could give, it's 0 to 90 days. It's 0 to up to $500.
So I guess if a person is camping or essentially homeless and they get a Class 3 misdemeanor and they end up in the county jail for 3 months or even a $500 fine, let's say they spend 3 months in the county, they get out of the county, where are they going?
So let's go through the process. So let's say Mike was camping illegally. And the idea that there is signage, that this is an area where you can't camp, and Mike was informed, those are the first 2 steps. At that point, Mike is not moving. Mike is arrested. So let's say the judge does go the maximum and goes, okay, Mike's going to get 90 days. At that point in time, Mike does have an opportunity to hopefully get the help he needs, potentially well incarcerated. The idea of actually just turning our heads and not addressing it and continue to let Mike stay in that area and continue to camp. We know Mike's not getting any help. The services aren't there. But that deal of Mike getting either 0 to 90 days or 0 to $500 fine, of course, that's up to the judge. But the idea is also to make sure that we make sure Mike has that opportunity and knows, for example, go to 1702 Nicholas, the Francis House. There's an opportunity there for shelter.
If Mike is homeless and Mike gets the $500 fine, who's going to help Mike pay the $500 fine? What service is out there that's going to come to Mike and say, hey, Mike, I know you're homeless. I know you just got charged, and I know you got assessed a $500 fine. We're going to help you pay this fine.
And I don't want to turn this into a 211 discussion, but actually with the idea of the 211 services that are offered through the United Way, there is those assistants for someone that's actually reaching out to say, hey, I've been fined for this reason. This is going on in my life. There is that ability to reach out to the community to actually get that assistance. Now, I also think judges are compassionate and they look at the individual. The goal isn't to try to put people that are homeless in jail. The goal is to try to get them in an area, if the local government so chooses, that's designated for camping, and the idea that the services are there. But for that individual, for Mike that won't move, that says, no, I'm not getting help, I'm not leaving, I know you posted the sign, I know you communicated with me, because that's part of the law, that you have to move. At that point, then Mike's going to go to jail, and the judge is going to have to decide on what's the best plan for Mike going forward.
Let's say there's 1,000 people that are homeless in homeless camps. They all go through this. They all get either charged $500 or end up spending some time in the county. Is that more cost effective than just getting them help on the front end?
No, and I think that's why you have to communicate with them first, and that's part of the law. You know, similar to what they did at the state level and the county level, it's currently on the books for a Class 5 misdemeanor. The idea that we're doing is trying to say, okay, you put the signage up, they know this is not a camp area, you communicate with them, here's your options, here's the place you can move, because the local government against this isn't mandated. It's based on if the local government wants to put this in place. So the local government puts it in place and says, okay, there is a camping area, making this up on, 10th and X, whatever the point is. At that point, there is services and you can go camp there. You cannot camp currently where you are because it's prohibited. And also, if you don't move, yes, there's going to be action taken against you, but there is a place that you can go camp based on the local government saying this is a designated area for camping. Now, we know we have service, and I'm using Omaha as an example, the Francis House, that there is a homeless shelter. We know we have 211 throughout the state for people to call for assistance. If it's food assistance, if it's shelter, it's paying your utility bill. There's people out there that want to help with that. So the idea is to try to educate and make sure those individuals that Mike could be homeless because he lost his job, Mike could have a drug addiction. There could be a number of different things. There could be a mental health issue. The idea is to make sure that the local government has another tool in their toolbox to say, here, we're going to designate an area similar to a FEMA site in a natural disaster. And we're going to make sure that you can camp there, but we're going to have services provided for you there. Not just that you can sporadically pop up and camp throughout the city where there is no services. There's no help or services in those tents. There is people that want to help, but we have to do it in an organized, compassionate manner.
So has the city of, let's say, the city of Omaha, or has Douglas County indicated that with the possible passage of this bill, they're going to designate areas within their boundaries as homeless campsites or encampments within their boundaries?
So if this bill passes, it's not a mandate. So the bill's on the books, so the statute's on the books. The local government then says, okay, we're going to enact that. We're going to put the signage up. We're going to make sure we communicate with people to get them help. And then we are going to designate a certain area, block A, B, and C
But
as
I think that's what's confusing, because I don't see anywhere here that it says they may enact this or anything like that. I see section 2, for the purposes of this section, camping means temporary lodging out of the doors presupposes the occupancy of a shelter designed or used for such purposes, such as sleeping bag or tent. 2, it shall be unlawful to knowingly camp on property owned or controlled by a political subdivision not designated as a campsite by political subdivisions when noticed that the property has not been designated as a campsite. But you're saying it's not a mandate, but if this passes and there aren't any designated campsites, that means once this passes, all these people are violating the law, and it's no way for them to not violate this law, because outside of going to parks and recs, they have nowhere to go.
no, well, it'd have to be a designated camping area. So
No,
the idea
that's what I'm saying. There's nowhere in Douglas County or the city of Omaha where they could go once this law passes.
well, we do know that. That's 1702 Nicholas. You can go there right now based on a homeless shelter. The idea of what my bill tries to propose is you can look at an area and designate it. Now you can put signage up saying on street 1, there's no camping. And you can put that signage up. You can say on street 9, there is a camping area that you can bring in. And as I give my example of a tornado natural disaster site where FEMA sets up with the idea of restroom, showers, the ability to feed people, and those wraparound services, that's what the goal is to say. But also, let's make sure we understand this. I totally oppose someone camping in front of Sherry's Bakery. Then the idea that they're setting up in front of Sherry's Bakery, if the signage has been posted and it's been communicated to that person, you can't camp here. This is not designated for a campsite. You can go down to X Street and camp there based on their service for you. That is the overall goal, is to say that there's, again, Mike sets up a tent on 9th Street. There's no services, there's no help. I don't think that is actually dealing with the long-term problem of homelessness.
I don't think this bill deals with the long-term problem of homelessness. Because I think it's jumping the gun. Because unless Douglas County or the city of Omaha designates campsites, this passes, and those people who are homeless And for whatever reason, whether it's mental health, substance abuse, it could be varying issues. You know, we got kids aging out of the foster care system that DHHS is just throwing on the streets, and we're not holding them accountable, but some of those kids are going to be in violation of the law because the state refused to take care of them. So I feel like unless the city of Omaha or Douglas County is going to not April 15th, 16th, 17th, or May, whatever, unless they are willing to step up tomorrow and say, we're designating X portion of this county or city as a designated campsite, it's no way we could pass this bill, because we're just going to incriminate a bunch of people who, for no reason at all, I'm not saying they should be in front of anybody's business camping out or on the side of people's homes, because I see it, because it's encampments in my district. I'm just saying the city and the county need it, unless they're willing to step up and designate spaces. We couldn't pass this bill because we're gonna directly incriminate people who should be incriminated.
And this bill, again, doesn't mandate to the city what they have to do. This is an option. But we already know, based on state and county property, this is a law. This is current, and I don't see anybody trying to repeal it. I don't see right now any discussion in my 7 years of anybody trying to repeal the current state and county law based on the idea of designated camping areas. So right now, this is adding a political subdivision, if they so choose, and based on the three things. First of all, you've got to post the signage, you've got to communicate to the individual, and then the idea of the enforcement. Now, at that point, the city does have the ability to say, okay, we are going to go ahead and designate area A, B, C, or whatever, street 9, 10, 11, to actually a designated camping area. But you cannot camp on the areas that we're going to post the signage and communicate to you that this is not a legal area to camp. But also, I think one thing we're missing is, as you drive by those things, you think there's services right now in those tents? You think there's people there assisting them, helping them? If you would put a designated area, just like a FEMA site in a natural disaster, and give those services and say, yes, there is help here. There's different areas. If Mike's having a mental health issue, if Mike has an addiction to drugs, if Mike just lost his job, there's ways to deal with that. But unless we actually start looking at the root cause of the problem, we just can't be letting people camp throughout the city and not getting any help.
But if
It's not good for business. It's not good for public safety.
But if we're looking at the root cause of the problem, we would realize that criminalizing that situation isn't even close to the solution. Because even if we pass this bill, how many of them pay attention to what's going on right now? How many of them are aware of what laws change every day?
And that's why I think if you look at the bill on page 2 and look at actually line 14 and 15, you have to actually communicate with the person. You have to actually make sure the posting in a manner prescribed for the law reasonably to make sure that people know that they can't camp in these areas. And this isn't what we're mirroring is the current law for the state property and for county property. We're just saying that the local subdivisions, the local governments have an opportunity to also make sure that this is done in a way where people aren't camping in areas that are posted that you cannot, to make it safe for the citizens, for those business owners, but also at the same time trying to make sure that we give an opportunity for those people to get help that need the help in a designated camping area.
Okay, thank you, Senator McKinney. Other questions from the committee? Senator McDonnell, I do have one for you, and I don't even know how to phrase it, right? So I'm gonna be a little sloppy here. I keep hearing you say, you know, there's no help in those areas, and you're gonna set up a FEMA site, something like a FEMA site, something like that. What if there are folks who don't want to live in something like a FEMA site, who don't want to get services, who don't want all of these things?
So let's say it's Mike and he's camping and
He just does.
I see the sign, I see, okay, and I'm camping in front of your business on the sidewalk. And I see the sign, I come up, it's communicating to me, hey, you can't camp here. You can go to the designated camping and there's help there for you. Or again, just as today, Francis' house. And Mike says, no, I'm not moving. Mike is going to be arrested.
So,
Just like right now, if Mike was doing that on state property or county property, Mike is going to be arrested. And right now, Mike's charged with a class 5 misdemeanor. As the state law right now dictates based on state and county property. What I'm saying is that based on that local government saying, hey, we're going to put that it's prohibited in these certain areas. I think they should also look at a holistic look at trying to have a campsite to where Mike could go and give Mike that option, but there's got to be services there. It just can't be somewhere we're just letting people camp without the services. If that's the case, I don't think we're helping people.
but I guess what I'm suggesting is, what if there are folks, there's a huge group of people who might be in these kind of camping situations. And what if there's a small subset of those folks who just, for whatever reason, they're a free spirit, they have a different sense of things, they don't want services. They're not a drug addict, they're not a whatever, and they just want to live differently. They just want to kind of whatever.
And they can do that in a designated camping area. They just can't do it in front of your bakery on the sidewalk.
And what's the state law now? The
State law is a class 5 misdemeanor.
for camping in a non-designated spot?
Yeah, I handed it out. You guys all have it in your
Yeah.
packet. So right now, it's a class 5 person who camps on any state or county public highways, roadside areas, parks, other property acquired for state highway purposes, which has been properly designated as a campsite, or any person who violates any lawfully promulgated rules or regulations properly posted to regulate camping in designated campsites shall be guilty of a class 5 misdemeanor.
Okay.
But you guys all have a copy of this.
Okay, thank you, I found it. Any other questions? Senator
I will
Levy?
be here to.
One more question. The Douglas County voted to oppose this bill. So if the county doesn't support the bill, and then if the bill passes, if the bill passes, what faith do we have that they're gonna set up campsites?
The county's already covered by the current state statute. So this would be for the local subdivision, the city of Omaha, for example. Scottsbluff, a city, because remember, the county property and state property is already covered by the current law.
So how does the city of Omaha feel about this?
No, remember, this isn't mandating, this is giving them the option to put something in place. If this law goes into place, it doesn't mandate they have to do this, it gives them another tool in the toolbox to use.
It doesn't mandate it, but it still makes it a crime.
Just like right now, the state does. The state on state property and county property makes it a crime. This would also make it a crime. The goal isn't to try to make it a crime. The goal is to try to get areas which, if a city council, again, Scottsbluff, Omaha, says, hey, we would like to designate these areas that you cannot camp, but we are going to designate an area with services that you can camp. That would be up to them. This doesn't mandate them to do anything. This gives them the opportunity to do it if they so see fit. So Grand Island might say, oh, we're not going to do that. City of Omaha might say, we're going to do that. City of Lincoln might say, we're not going to do that. But right now, it mirrors off the state law of the state and the county property with a class 5 misdemeanor, even though this is a class 3 misdemeanor.
So why not do a class? I'm not even saying I support that, but why not do a class 5, or why not just do a bill to say a political subdivision to set up campsites and set aside $20 million?
Yeah, I don't want anybody to misunderstand. This is to deter camping in unauthorized areas. But at the same time, if you then give a certain area where you can camp, to make sure that there is those services there to help people. But this isn't any way to say that I'm trying to say that it's okay to camp on the streets, on the sidewalks throughout the city. But then again, there's reasons why people are doing that. There's mental health, there's addictions to drugs, alcohol, there's a number of different reasons. At the same time trying to address that, but making sure that it's always number one is public safety. Always number one is public safety. So is the public safe? Okay, are those businesses thriving? Are these people then getting an opportunity to get the help they need? I think we can do that in a way that hasn't been looked at. And again, I use FEMA as an example for a natural disaster area. But when you see that set up and the services that can be provided to get people a chance to actually go a different direction and get help, of course, if Mike's got a drug addiction, then get the help that he needs. That's the goal. But remember, it's first signage, second communication, third is enforcement.
But if public safety is the overall end goal, why not allocate or try to appropriate money to help these people?
Oh, well, we have appropriated money to help these people. Think about this. The idea that all of a sudden taking a campsite and saying that you cannot camp and there's 10 of us camping, that we have to move to another location, or there's the Francis House or other services, there is money that's been appropriated by the state to help people. I'm just in executive session right now with in appropriations, and we're talking about a number of the different bills that actually give people a chance. Now, Mike might be that person that doesn't want the help. Mike might be that person that says, I'm not moving. At that point, we're going to enforce the law, and Mike is going to be moved. The goal isn't to try to get Mike to resist. The goal is to try to get Mike to communicate with Mike. He knows that he can't camp here, and also let Mike know that there is services out there that can help him. But just to let people live in tents and set up sporadically throughout our communities and not get that help and just look the other way isn't going to be good for public safety. It's not going to be good for business, and it's not going to be good for that individual living in that tent.
All right.
Thank you, Senator McKay. Senator Blood.
Thank you, Vice Chair DeVore. So I just want to follow up on the public safety. Did you give us data that shows that?
Oh, it's coming. Yeah,
So
the
we
data.
have data that shows that.
It's coming. You're going to have testimony about the idea of the crime that's being committed. And not, again, there's a certain percent.
You didn't know what question I was going to ask, but it sounds like you're going to answer it anyway. So go ahead and answer it and I'll see if you're actually, I didn't finish my question.
Go ahead, finish.
So you started to answer it, I think. So you have recent data in Nebraska that shows that there is an increase in crime that pertains to our homeless communities
There's going to be law enforcement testify
that has data.
that has data.
All right, thank you.
And that was the question I was guessing you were asking.
You should let me finish.
Thank you, Senator Blood. Any other questions? I think that might be it, Senator McDonnell.
I will be here to close.
Okay. Let's have our first proponent.
Good afternoon. Thank you for the opportunity, Senators. My name is Kurt Trivedi. Legal name is spelled K-I-R-T-I. Last name T as in Tom, R-I, V Victor, E Edward, D David, I. I live in Omaha, Nebraska. I own businesses throughout Nebraska and Kansas. I'm based in downtown Omaha. I have been doing business in Nebraska for over 20 years. This discussion I have been having for 20 years. The crime that I experience, and I will go into very much detail, directly equals to the amount of encampments that I have in our business neighborhoods. When the encampments are removed, the crime rate that I experience on a daily basis goes down. When the encampments increase, the crimes that I experience, my employees experience, my customers experience increases astronomically. Examples of these crimes, and these are daily. Masturbation in public, exposing genitalia to kids and women. Defecating and urinating in my lobbies. Attacking and pushing my employees against their cars when they're walking home, when they're going to their vehicles after work. Recent situation was 2 pregnant females that worked for me. Customer cars being broken in every day. Recently, I had a bicycle thrown at me. We have videos of this. We have documentation because we do use now off-duty police and ex-military to provide security. I'm losing my livelihood. I'm not saying that it's the people in these encampments that are creating it, but there is a direct connection. This is not an anti-homeless agenda by me. I just want the laws to be followed. And yes, there's a separate path. The homeless situation is all of our problem. All. Every citizen of Nebraska, every politician, every law enforcement officer, it's our problem. But do not compromise law and order while we're addressing homelessness with an emphatic solution. You lost right there. We have been doing this for years and it's never been done right. You cannot compromise following laws that and making sure people's actions don't hurt other people's. You said, Senator McKinney, you had mentioned that you don't want encampments in front of businesses. They're in front of my business. I'm going to lose my business, sir. I've been here for 20 years. It's going to go. Omaha World Herald article just yesterday, where a faith-based organization allowed encampments within their own property and then dismissed them all because saying it got out of control. Two separate issues. We need the law to be followed, but at the same time, we need, and the private sector will step up, emphatic solutions to homelessness.
Sir, I'm sorry.
But I'm done. I'm sorry.
So your red light.
I'm pretty passionate
But I
about this.
think, no, that's great. I think you'll probably have some questions.
Absolutely.
Senator McKinney?
Thank you, Senator Board. Thank you for your testimony. I would first say that society got lost when we prioritized locking people up who had mental health problems, who had economic issues and those type of things, and we just sent them to jail and we over penalized them and enhanced penalties. I would say we also got lost when we, instead of diverting resources to communities that were impoverished, instead of putting resources within those communities, we decided to inflate police budgets. That's where society got lost. And when you say that the private sector will step up, what have you done to step up to help these people?
I offer them jobs daily. I offer them food. We donate supplies daily. Sir, but what you said earlier, may I comment on that?
What exactly?
The first part, where you're saying police budgets inflated and so forth. I understand that, and that may be so, Senator. But that, addressing those issues at the expense of my livelihood, at the expense of my customers, my personal and my employee safety, that's not right. There are two separate paths, sir. There is law and order, because law and order protects people from the bad behaviors of other people. And the emphatic solution to homelessness is a completely separate path. So yes, the private sector will step up, and I am an example right here in front of you, sir.
Did any of my statements say that I wanted your employees to be assaulted? Did any of my statements say that I wanted people to be camping out in front of your business? Did I say any of that?
No, but you dismissed my comments and you went to those other topics, and that doesn't solve it.
No, because
right now,
your
the situation today is my livelihood, my people's safety, public safety, the laws that are on the books, let's enforce them. Let's keep people safe, but also a separate topic, a separate lane, emphatic solutions for the homeless. Absolutely.
You know what?
But not at the expense of us.
You want to know why I dismissed your comments? Because you're advocating for a bill and you're ignoring the unintended consequences of the passage of this law. That's the problem.
What about me then?
What about you?
I'm being ignored right now.
Those people will be ignored and locked up.
I'm being ignored right now, sir. What about me?
So I guess everybody will be ignored.
If that's how you would like, then you're in a
That's what
position
you
of
would
power.
like. That's what you would like with advocating for this bill.
Sir, you're twisting my words.
No, I'm
and
not.
Yes, you are, sir.
No, I'm not.
You are ignoring, I'm talking about what's happening right now. These are actual things that are happening. Read the paper. I can provide you documents if you'd like. I've been keeping track of this for a very long time. This is not an anti-homeless agenda.
I guess
Absolutely
I don't know how
not.
to read.
Okay, let me know when I can speak, sir.
Speak.
This is not an anti-homeless agenda. This is keeping people safe. This is keeping downtown Omaha, West Omaha, Eastern, Western Nebraska, your home, my home, trying to make sure that we do our best job to keep people safe. Now, on the other side of the ledger, there is a homeless issue. There is mental health issues. It is serious. It is not your problem. It's not mine. It's all of our problem. But if we're going to sit there and compromise laws and the safety of other people to address this, it hasn't worked, sir. It hasn't. The country's been trying it for a very long time. It has not worked. So try
Enhancing
something
laws
different.
haven't worked. Enhancing laws haven't worked. We just fill up jails and prisons. We're building a $350 million prison because this country has decided to just over-incarcerate people and incarcerate people because of poverty. That's the problem.
Senator, I'm not here to talk about prisons.
That's the problem. That's the problem.
Allow me to finish.
You're advocating for increased
We can't talk over each
penalties.
other. I want to dialogue with you, Senator, because I really appreciate what you're saying.
Though.
But let's not talk over each other. So what I'm talking about today, we're here about a bill to prevent encampments in certain areas. Right now, we can have encampments in some places, but we can't on other people, depending on who owns the land. That's not right either. If the state, can we have one right here in front of the Capitol?
Sure.
Are you going on the record saying that?
I wouldn't mind it.
No, but can you? Is it lawful?
I wouldn't mind it.
Is it lawful, Senator McKinney?
I wouldn't mind it.
I rest my case.
Rest it. Thank you.
Thank you, Senator McKinney. Other questions from the committee? Thank you, sir, for being here. Next proponent. Welcome.
Welcome. Thank you, honorable members of the committee. My name is Aaron Hanson, Aaron Hanson. I'm the sheriff of Douglas County. This is an emotional topic for sure, but it's a conversation we must have. We must have. And despite the conversations, the tough conversations and the tough questions that I hope I get, and that I hope you also give to the opponents, there are no bad guys. For the most part, most people agree we have a big problem. It's how we solve the problem that we disagree. I can tell you, as a 28-year law enforcement officer, who over the last few years has spent a lot of time in these tent encampments, if anybody tells you that these tent encampments are the equivalent of a campout, where people are sitting around a campfire, roasting marshmallows and hot dogs, they are not telling you the truth. These are deplorable situations that these folks are living in, and it's not homelessness. I spoke with an individual yesterday who was temporarily homeless. She did not end up in a tent. She's familiar with people that live in tents and the conditions, and she agrees it's deplorable. She would have went to a shelter, lived with family before she did that. I have encountered individuals in these tents that are living in some of the most unhealthy conditions you've ever seen. Wounds that are unhealed, health conditions that are terrifying, mental health conditions that are unaddressed, addiction issues that are unaddressed, and that's the deplorable situation these folks in these tents are living through. Then you have to look at the folks who live and work and traverse outside of these tents. People are having their mail stolen. People are having their possessions stolen. People are being threatened with weapons, assaulted. Campsites that are catching on fire, catching homes on fire, catching businesses on fire, burning people in the tents, people being raped. I've literally talked to women who are so addled with addiction and mental health issues that they would rather live in a tent where, by their own admission, they have been almost raped and assaulted and had lighter fluid thrown on them and almost caught on fire, as opposed to living in a shelter. Why? Because in the shelter, you have to follow rules and be sober. So please, ask me tough questions, but especially with the advocacy crowd behind me, dig in deep. Ask if there's anything good and positive about living in these tent communities. There's not. The free spirit does not exist that I have ever found. And if they do, they're not living in a metro area, in front of a storefront or in an alley. Think about the people in the tents and their real needs. It's mental health and addiction challenges. And think about the people that live outside of those tents and how that impacts them. I'll take any questions you have.
Are there questions from the committee? Senator McKinney.
Yes, sir.
Thank you, Senator DeBoer. Thank you, Senator Hansen. So the solution to people living in deplorable conditions is to increase penalties on them?
No, I think that we need a safety net. Ultimately, we need a three-legged stool, just like we do with most of these public safety approaches. Intervention, prevention, and suppression. And right now, we do have, I'll admit, not enough. We do need a behavioral regional center in Douglas County, in my opinion. But we do have resources towards intervention and prevention. The reason why we need the suppression leg of the stool is because there are acute cases. There are severely impacted people who, through their own addiction and mental health challenges, will not take advantage of the other two legs of that stool. There needs to be a safety net. Now, should the story end there, Senator, your point? No. We need to invest in robust diversion programs. We need to invest in robust probation programs to give people the structure and supervision they need to get out of the lifestyle that put them in that tent in the first place. So that's not the end of the story. The criminal justice part, the incarceration part, hopefully will not be the end of the story. But just because it's not perfect now, doesn't mean we cast this potential tool out of the toolbox.
So how do we get here if you agree there's a lack of investment there?
Because these things are not mutually exclusive to each other. We're not going to find the out-of-the-box solution with all the pieces of the puzzle in place. It's not possible. We need to take this incrementally. I have been a strong advocate for the need for a regional center in Douglas County. Of course, we need enhanced behavioral health care infrastructure, especially for the most acute cases. But just because we do not have perfection on all those areas yet, does not mean we cast aside the tools that we also need, the enforcement tools to keep people safe.
But when you say keep people safe, but if somebody is dealing with a mental health condition like schizophrenia or something like that, putting them in a cell isn't safe for them.
Well, I will tell you this, Senator, and actually in Douglas County, they are investing in specialized behavioral health corrections infrastructure. Now, hopefully that will result in, once people exit that infrastructure, getting inbound into services that are community-based. But I can tell you that I think we are evolving, I hope we are evolving, to not just throw people in a cell, but to use that correctional phase in a way to help get people's feet under them with the hope that once they leave that they can be received by community-based services that can help them even further.
But that's my issue. We're hoping that these things will be in place.
That's happening though, Senator. That's happening.
Currently, if somebody with schizophrenia gets arrested right now and they go to Douglas County Corrections, they will be placed in a mental health unit.
It's not built yet. They've approved it. They're building it.
But that's my problem. If this bill passes, although it's being sold as like an option, either I'm reading this language wrong, but if this bill was to pass, those people are automatically in violation of the law.
I see it differently. There's two things here, Senator. Number one, if a municipality or natural resources district or some local government said, hey, we want to make sure clear, our public policy is there is no designated camping area. You're allowed to camp on any public space that you want to. There's nothing in this bill that would prohibit any local government from saying that. If the policy of the local government was, it's okay to camp wherever you want on public property that we're in control of, that could be a public policy. Or they could drill down deeper and say in these designated areas, or they could say nowhere. But again, Senator, that individual with schizophrenia, I agree. I wish there was resources for that individual now that was better than a jail cell. But I can tell you this, a lot of the people I've spoken to, people who have been assaulted, people who have been chased with weapons, people who have been victims of crime, they would have preferred to have that individual in a jail cell if that's the last option in order to help get them onto a better track. That's where we need the balance.
But if those people were chased with a weapon, that's a violation of the law.
If you can prove it was them, you have to prove it was them. You have to find them A lot of these people are very transit. You have to prove that it was them. It's not that easy. To Mr. Trivedi's point, it is the collection of the population that causes the problems peripherally. It is easier said than done to say that just because someone was chased down the Keystone Trail with a knife, that I and law enforcement are going to be able to go and identify that person, arrest them, and charge them.
But when you say it's the collection of the population that causes the problem, there's also another argument that says it's the collection of the willingness to continue to try to use enhancements of crimes as deterrents instead of doing all we can as a society to give every resource we have to these people. We're literally dumping $600 million into a canal that's going to be stuck in a litigation for 10 plus years and may never happen. I'm just saying, as a society, we waste a bunch of money on things that we probably shouldn't waste money on instead of giving people proper resources. We say we're the greatest country in the world, and we have people living in tents. Something is wrong. And that's all I'm saying.
I don't disagree with you, but at some point, you need safety nets for all of these options, and we can throw money indefinitely at the problem. Do I think we should invest more? Absolutely. I've been an advocate of that since the day I walked into this job. But we also need safety nets.
But what I'm saying is, you're saying we need safety nets, but if a person with schizophrenia goes to jail now, they're not going to in Douglas County. You're saying we're hoping that eventually they're going to open up some type of mental health facility or unit. That's currently not available. So right now, if this was to pass, I would have schizophrenia, get arrested for this, and just be stuck in a cell and further diminishing my health and my mental health especially.
Well, and here's my response to that, Senator. I think that by not having that affirmative safety net, we are actually increasing the chances of those individuals committing a more serious crime and finding themselves now committing a felony and being in the prison system that many of you are concerned is overcrowded.
But what my point is, by not having services and things in place to help people with schizophrenia currently, that person goes to jail if this was to pass and their mental health further diminishes. We release them after 3 months. Isn't that more of a public safety issue?
That is definitely where we need to do better. And I think that Douglas County is proof that we are trying better. Do we need more support from the state in terms of enhancing those efforts? Absolutely. We need a regional center in Douglas County, in my opinion. We need to improve our emergency protected custody laws. We need to improve our Board of Mental Health laws. We need to give more support to our Board of Mental Health to have better structure and supervision. You're correct in that we need to do more. This is one piece of a larger puzzle, and we should not cast it aside simply because we don't have all the other puzzle pieces in place.
I just think that's unfair to those people, just like you argue it's unfair to those other people. I think fairness goes both ways. That's all I'm saying.
I understand.
Thank you. Any other questions? Senator Boyd.
Thank you. So I take your free spirit piece. Apparently that's not a thing that happens.
I have never found that. I've never come in contact with that with these homeless encampments.
Okay. So I think you were talking about this, Senator McKinney, but are there enough services for everyone if we do this? I mean, can we find services for all the people that are going to sort of catch them, get caught up in this situation?
You know, that's kind of the point. How big is this going to get? Yeah. And eventually, where do the services that we do have? And I can tell you whether it's Sienna Francis House or New Horizon or Open Door Mission, the services exist. Unfortunately, a lot of people that are struggling with behavioral health challenges or addiction, those challenges don't want them. It's a struggle for them to enter through the traditional entry points to move up through the process. But I can tell you, I've walked through the Miracles Addiction Recovery program on the Santa Francis House campus. It's amazing. It's clean. They do good work. Every time I've been there, I've been advised they have bed space available. They have good people. They get good results, and you're not rushed out. There's people that can be in that program for a year or more. They help you get employment. If you look at many of the services in Douglas County, we have exceptional services available. Could we support them more? Absolutely. Should we? Yes. But we're not maximizing what we have.
So you think maybe there would be enough services for everyone who would get caught up in this?
It is my understanding that when it comes to shelter space, I have heard that we have ample shelter space now. Could we use more? Could we use shelter space that allow people to have a pet? Yes. Could we have shelter space that's more for parents with kids? Yes, but we have those. I believe to my core, the services we have are available and ready to assist if people want or have the ability or capability to engage in them.
Okay. So one other question is, do you think it would be appropriate to require a subdivision or whoever is going to sort of post the no camping signs to have a designated camping sign? Like if you're going to put the no camping signs, then you got to have a place for people to go. Would that make sense?
I don't know the answer to that. I think that that is a question which is most appropriately left to local control. I think that that's a question that should be left to the local government municipalities, because we're not just talking about cities, we're also talking about resource districts, could be community colleges. I don't know that everyone should be shoehorned into having to have a designated homeless encampment area. But I do believe that there's enough community partners out there that you could have a discussion, talk about the resources that could be available if you did designate those areas. And if you have to have people living in tents, at least give them a real option at recovery and connection with services.
Your question, Senator Lowe.
Thank you, Chair Wayne. Thank you for coming in today. I just have a real quick question. So I heard a couple times that this isn't a mandate, and you heard something that I like to hear, which is that it should be local control and up to the local government. So would you be okay if we change the word shall to may in the bill?
I'd have to read where the shall would be replaced with the may, but
Because shall says it's a mandate, and may would indeed do exactly what you just said it would do, which is give the political subdivisions local power, local control.
sure. I think that I believe I might be open to that, because here's why. My office gets flooded with people all across the county concerned about this, upset about it. They're empathetic to the plight of the people living in the tents, but they're concerned about the existence of the tents and the crime around the tents. So I believe that through a natural process, that local government would probably end up enacting the may, because their constituents would want them to. So I think that'd definitely be something, a discussion that I'd be open to.
So here's the harder question then, and this was not meant to be a trick question, this just came up in my head while you were talking. So then they could actually do that without the statute?
No, because I think that what you're seeing right now is there is this gap when it comes to statutory or local municipal rules that confuse someone's ability to be on public property. Unlike the bright line that we have with county and state property, it gets too confused in terms of someone's ability to just stay on a sidewalk as opposed to putting a tent on the sidewalk. I think we do need to give the bright lines to make clear that these unauthorized tent encampments, that is against good public policy.
Thank you.
Any other questions from the committee? Senator Ibach.
Thank you, Chair Wayne. I would like for you to help me, and I apologize, I missed the opening comments, so if I'm redundant, I apologize. But help me understand the scope
and the urgency. Maybe give me a perspective. I mean, we all watch the news and we see coastal cities that are just almost devastated by it. Tell me where we've been in the last 5 years and what the trajectory is
Sure.
for
We've seen-
homelessness in 5 years.
We've seen a triple-digit increase in homelessness. And I can tell you, as someone that started my career in District 47, 48 in North Omaha in 1997, we didn't see these tent encampments. And that was the Francis House District. We did not see these tent encampments. It was a rarity to find an encampment, and usually it was going to be a ramshackle building of pallets put together by some industrious individual. And actually those are pretty interesting structures. There's usually a wood burning stove in it. We have seen an explosion, an exponential explosion of these tent encampments. And if you look at the West Coast, and I think if you look at our neighbor Denver is at the tipping point. It has grown so big that I don't even know if they have the services to support even providing all the folks that are in those tents with services. They are actually in the process of shutting down basic city services to accommodate the needs of these large growing tent encampments. So what I'm proposing is that we are 4 to 5 years behind them. We have an opportunity to interrupt that trend right now. Harm reduction alone, although it's good, will not do it. We have to have the three-legged stool. We have to have the enforcement option as well.
Okay, great. Thank you very much. Thank you, Chair.
Any other questions from the committee? Seeing none, thank you for being here as always. Next, proponent. Welcome.
Thank you, Chairman Wayne and members of the Judiciary Committee for giving me an opportunity to support LB 1357. My name is Devin Kurtz, DEVONKURTZ. I'm the Director of Public Safety Policy at Cicero Action, a nonprofit research institution based in Austin, Texas. I have worked on this issue in nearly 20 states. I'd like to offer some statistical context for this discussion. Only a small subset of the homeless population engages in what is known as street camping, which is the topic of discussion here. Approximately 87% of homeless Nebraskans sleep in the more than 2,800 available beds in homeless shelters or transitional housing units. But the remaining 13%, approximately 312 individuals, sleep outside, despite there being enough shelter beds in this state to house them temporarily. Unsheltered homelessness, the term used for those who engage in street camping, is quite different demographically than homelessness in general. To start, families represent about 30% of the sheltered homeless population in Nebraska, whereas the unsheltered population includes only 2 family households in the state. Approximately 2/3 of Nebraska's unsheltered population is male, and most are older than 35 but younger than 64. The unsheltered population suffers from high rates of severe mental illness and chronic substance abuse, both of which have become far more prevalent in that population over the last 10 years nationwide and in the state of Nebraska. Since 2013, the number of unsheltered homeless with severe mental illness has grown by more than 300%, or quadrupling. Those with chronic substance abuse have more than doubled. As a result, unsheltered homelessness has a 2.5 times mortality rate of those in homeless shelters. These factors are important context when considering this bill. Unsheltered homelessness in Nebraska is not simply an issue of economic distress or inadequate response mechanisms in communities. Unsheltered homelessness in Nebraska is driven by high-need individuals who cannot or will not accept shelter and services because of their limited mental faculties, addiction, or individual decision to refuse help. These are not acceptable reasons to allow someone to sleep on the street and endure the harsh elements of the outdoors. Indeed, to permit them to choose to suffer outdoors is cruel. LB 1357 addresses this issue by empowering law enforcement to move unsheltered homeless people off of the street as a last resort if those individuals don't accept shelter or services from homeless outreach teams, churches, or other members of the community who engage with these individuals every day. Cities like Austin, Texas have seen success using this policy, accomplishing a 19% decrease in unsheltered homelessness and 20% increase of those in shelters within only 1 year and only 1 arrest. This bill is a first step for Nebraska to respond more comprehensively to a growing unsheltered homeless crisis. I have additional data at my disposal and be happy to answer any other questions. Thank you.
Any questions from the committee? See, do you have one? I figured you did. That's why I was pausing. Go ahead, sir. Senator McKinney.
Reading your thing, I see your point. What is this? Point one on one of your final paragraphs on your first page. It says, you say that there is enough homeless shelter space available for people currently homeless on the streets of Nebraska. What makes you think that's true? Because there's a lot of people in this room who work at homeless shelters who are behind you shaking their head.
Sure,
So
sure. I would be happy to offer.
Educate me on why you're from Texas.
Correct.
And people from Nebraska who work in homeless shelters are behind you saying that is an incorrect statement. So how are you, who from Texas, what fact do you have about the state of Nebraska and our homeless shelter population and our homeless bed availability that the people who work in homeless shelters have that you?
Sure.
What do you have that they don't?
The Department of Housing and Urban Development tracks all of this data that they contribute to. Thus, I have their numbers. So I can give you those numbers right now. In 2013, there were 3,728 short-term shelters available in the state. There were 3,100 homeless people at that time. Under what's called Housing First, a policy dictated by the U.S. Department of Housing and Urban Development through what are called continuums of care.
What's the numbers in 2024?
I'm getting there. Don't worry. The U.S. Department of Housing and Urban Development gives Nebraska approximately $12 million a year in homelessness funding. Most of that funding is used for what's called Housing First, which is the prioritization of what's called permanent supportive housing over short-term shelter like emergency shelter and transitional housing. So the number, 3,700 short-term shelter, 3,100 homeless in 2013 has changed. In 2023, the most recent count, 2,800 short-term shelter, a decrease of almost 1,000. At the same time, the homeless population has decreased to about 2,400 in the state. However, unsheltered homelessness over that period has more than doubled since 2018, and since 2013, it's about an 80% rise. In addition, the proportion of homeless in the state that's unsheltered has doubled. So more people that are homeless today in Nebraska are unsheltered and homeless than they were 10 years ago, in large part because of these policies enacted by the folks behind me.
What policies?
Housing First, which is deprioritizing short-term shelter. It's literally taking transitional housing, converting it into a different type of housing that hinders a community's ability to respond to homelessness and get people into the services that
So
we're
your
talking about.
argument is that the homeless shelters that are available have policies that restrict those who would traditionally qualify to be able to utilize those shelters from being able to go inside those shelters?
Not correct, no.
What are you saying?
I'm saying that the what are called continuums of care, which oversee estates, and there's multiple in a state, but they oversee all of the dispersion of federal funding and grant applications for a state around homelessness. Those organizations have decreased the amount of transitional housing in your state by 60% since 2013.
So how are you arguing that we have enough beds?
We do, we still do. There's 2,800 short-term shelter beds and 2,400 homeless in the state. Those are enough beds.
So you're saying there's only 2,400 homeless people in the state of Nebraska?
According to the U.S. Department of Housing and Urban Development, yes. Which is the best data we have. I would love to have more data. I would love to do the annual point-in-time count every month. However, there's resistance within HUD to do that and the continuums of care. We could get more data and transparency, but the same folks who are saying there's not enough money, not enough resources, resist that in every state I go to. We're aligned on a lot of this. I hear you, and I've heard questions from the committee, and I do hear you. We want to have a more comprehensive solution. We want to have more resources, but right now the resources that exist are being misallocated. That's the problem. The problem is getting worse because of the misallocation of resources, not because of the scarcity of resources.
Okay, thank you.
Thank you. Any other questions from the committee? Seeing none, thank you for being here. Next
Thank you.
proponent. Next proponent. Proponent. Seeing none, moving to opponents. first opponent. Welcome.
So pleased to be here with you all on the last day of hearings.
There's
Chair.
no person I'd rather share the last hearing with.
You know, that's so nice. Let's get into it. Chair Wayne, members of the Judiciary Committee, my name is Erin Feichtinger, ErinFeichtinger, and I'm the Policy Director for the Women's Fund of Omaha. We believe that housing justice is gender justice. You've heard from me before in this committee, women are consistently overrepresented in eviction court. They are disproportionately impacted by housing instability and homelessness. In Douglas County, over 60% of tenants in courtroom 20, that's eviction court, are women. The number of women evicted is 16% higher than their male counterparts, and that number grows for Black women who are evicted at a rate 36% higher than Black men. 57% of all homeless women report that domestic violence was the immediate cause of their homelessness, whether through needing to leave or through an eviction. The most recent 2023 point in time count of the 1,475 people experiencing homelessness in the Omaha metro area, 109 of them identified as domestic violence as the reason they were homeless. The response to these numbers is not further punishment. It is not creating penalties for being in need. The response is addressing the root causes of homelessness, which is admittedly much more difficult than simply putting people in jail or fining them. I've already shared with this committee in previous bills the data on evictions, on housing instability, the repercussions of that instability, not only leading to homelessness, but impacting long-term stability for individuals and families here in Nebraska. You know that housing instability is growing, that eviction filings have grown from 6,286 in 2019 to 10,989 in 2023. We know that children are most at risk for eviction before age of 5. We know that having children in a rental household puts you more at risk for eviction, and evictions lead to homelessness. And while it is true that we are not currently equipped to deal with the level of the problem we are facing, it is not for lack of effort, and it is not for lack of hope. This bill represents the exact wrong response to our problem. Homelessness is not a personal choice, it is a policy choice. It is our collective failure to provide adequate resources and support. I have heard this bill is just another tool in the toolbox, but what folks have been asking you for is a life raft, and we are throwing you an amble with this bill. We have not done enough to solve the underlying problems to justify this response. And the people behind me can't say this, but I can. It is incredibly insulting to every single person in this community who spends their time trying to help folks, who take on the collective trauma of all of our communities that no one else wants to deal with, to then turn around and undo that work by saying, let's just put them in jail instead. I want to be clear that there are a lot of sincere, thoughtful, and compassionate solutions to homelessness, and that we can take serious steps towards those solutions together. Providing more affordable housing, increasing housing stability and safety of housing, economic security, mental health services, all of that work and those solutions are undermined by the reactive and punitive response represented by this bill. This is not a solution for homelessness. It is a penalty for it. It is a punishment targeted at those most in need, though it is our collective failure to help people. And I was just about to. And I am happy to answer any questions to the best of my abilities.
Thank you. Any questions, Senator McKinney?
Thank you, Chair Wayne. Thank you, Ms. Feichinger. First question, do you think there's only 2,400 homeless people in the state of Nebraska?
I'm going to tell you that there are people behind me who spend a lot of time analyzing that data, who are from Nebraska, who work in Nebraska, who work on the ground. And I'm going to let them answer that question. I do know that, the point in time count is just that, a point in time. And the people behind me who do that work every day are going to have a lot more, personal knowledge, are going to have a lot better numbers for you than I will.
Okay, last question. If this bill passed, would this just create an option for a political subdivision to enforce this, or would it also automatically criminalize criminalize these individuals that are living in tents or encampments?
I think that your questions earlier were spot on to that. The way that I understand this bill to work is that it would create a penalty for what has, I think, been in a folksy way called camping, but which we know is really targeting street homelessness. And I think you are exactly correct that we haven't figured out those other pieces. And if this bill passes, what we've done is create a punitive system that people are not going to be able to avoid. They're not going to be able to get like away from it. And yeah, I'll just leave it there for you.
All right, thank you.
Any other questions? Seeing none, thank you for being here. Next opponent.
Good afternoon, Chair Wayne and members of the Judiciary Committee. My name is Jasmine Harris, Jasmine Harris. I'm the Director of Public Policy and Advocacy at RISE, and we're here in opposition to LB 1357. The criminalization of unhoused individuals has become the go-to response across the United States to try and control the growing number of unsheltered people living and conducting daily living activities in public spaces. The definition of criminalization of homelessness is punishing unhoused individuals for doing things in public that every person has to do. For example, sleeping or sheltering against the elements. LB 1357 would do just that, criminalize people in the state of Nebraska. In 2014, the National Law Center on Homelessness and Poverty conducted surveys of 187 American cities and found that 34% of those banned camping, quote unquote, in public spaces, which increased by 60% since 2011. These types of laws have not decreased since then, but have rapidly spread across the country. I want to give you some data points. According to the Nebraska Criminal Justice Data Snapshot provided by the Council of State Governments, in January 2022, Nebraska had the third highest state homelessness rate in the Midwestern region and the 24th highest in the country. People incarcerated more than once are 13 times more likely to experience homelessness than the general public, and unsheltered individuals have had 10 times the number of law enforcement contact than those in shelters, and are 9 times more likely to have spent at least one night in jail in the past 6 months. And as we all know, the Nebraska Department of Corrections is overcrowded, and so are the county jails. This homelessness to jail cycle contributes to these numbers. LB 1357 would contribute even further. Criminalization of homelessness not only puts a strain on the criminal legal system, it worsens the issue of homelessness. This bill wants to make camping on public properties a Class 3 misdemeanor, which the penalties are up to 3 months in jail and or a $500 fine. This does not include the court costs and fees. As part of the Justice Study, RISE has case managers that work with individuals who are on pretrial. Our focus is on trying to ensure we are meeting people where they are and identifying the needs that they want to address to increase their chances of success. When we go through our needs assessment, the top 5 concerns are low and or no income, food insecurity, unfit housing, no employment, and none and or lacking adequate transportation. So when we are working with folks who are experiencing being unhoused and navigating the criminal legal system, majority of them have no means to pay for these fines, court costs, and fees, and barely the ability to get to the courthouse to appear on their court date, which causes more issues due to warrants for failure to appear. So what can we do to lessen the amount of people cycling through the criminal legal system and experiencing homelessness? Not pass laws like LB 1357, invest in affordable and supportive housing and wraparound services, and reduce housing discrimination due to someone having a conviction on their background. For these reasons, RISE opposes LB 1357 and asks the committee to not vote the same.
Thank you. Any questions from the committee? Senator Bottom.
Thank you. Thank you for being here. I appreciate your perspective. I guess one of the questions, you heard the gentleman who testified as a proponent, who's a business owner. Were you in here for that?
What do I think of it?
Were you in here for the testimony
Yes.
of the individual who's a business owner in Omaha community? Is it your position that there are in fact individuals who prefer not to go to a shelter?
It all depends. So when you're talking about people who are having mental health conditions or issues with their mental health, are they in that mind state to be able to make that decision? So it just all depends on where they are in that. We heard about free spirits. It's people's choice to be a free spirit if they want to be a free spirit. But if they're having a mental health condition, are they in that right state of mind to make that decision?
But even still, there could be some individuals who say, I don't want to go there. I just would prefer to not reside under those conditions.
There could be.
Right. So what is the solution for that gentleman's business? I mean, he presented some significant issues. I think we both agree that those are serious issues that are taking place there. And so my question is, if there are individuals who prefer not to live in the shelters, we aren't going to change their mind by, in your position, we aren't going to change their mind by criminalizing their behavior. What do we do with that? Because they don't want the housing that we could offer. I mean, your solution is to invest, I assume that's what you're talking about.
Invest in affordable and supportive housing.
If they don't want that, what is the tool that we should be using? And I didn't
Well,
mean to play gotcha, so maybe.
No, there's no
conversation.
gotcha when it comes to me. The thing is, we hear about FEMA, we hear about putting people in these shelters. All that is temporary. When you go to a shelter, you're there for the night and then you're back out on the street. So that's not even a solution. So we all have to come together and create things that are going to address poverty essentially.
Any other questions from Senator Blood?
Thank you, Chair Wayne. Thanks for coming in today. I have a question because I haven't heard this yet. But it was always my understanding working with homeless people that one of the reasons they don't go to shelters, and I am asking this in the form of a question, is because what personal belongings they have are their personal belongings, and often you'll see them like with a shopping cart or with like a rolling suitcase or some other way to transport it, and they're not always allowed to bring those possessions into the shelter, and so they have to decide between the possessions or the bed. Would you say that that's accurate still, or is that just from, because I haven't done volunteered there in like 2 years, so maybe things have changed.
I'm not sure what the policies are right now. We also hear anecdotally from people that we help with that sometimes they don't feel safe in the shelters. They,
Right.
So it's just all
Especially people with children.
what people have and what they're going through at that point in time.
Okay, thank you. Maybe someone else will come up behind and let me know that. Thanks.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Next, opponent. And I just want to remind people, if you hear something that was already said or don't need to, I just want your position recorded. There is a gold sheet that records your position for the record. Thank you. Go ahead.
Thank you. Good afternoon, Senator Wayne and members of the Judiciary Committee. My name is Tina Rockenbach, TINA. ROCK-EMBACH. I'm the Executive Director for Community Action of Nebraska. We're the state association representing all 9 of the community action agencies addressing poverty in all 93 counties in Nebraska. You've got some written prepared testimony there, and I'll let you read that at your leisure. I've got some notes here just from the conversation today that I think deserve being uplifted. And first of all, while we are in opposition here today to 1357, I do appreciate that it's opening this conversation. This is something that we work with on a daily basis and often see frustration in trying to get things accomplished. And we also want to recognize that we do feel that public safety and individual safety is utmost, and that's also what we look at when we're trying to connect people with our services. As the bill is written, we do have the concerns that have already been uplifted here today, and I'm not going to repeat those, but I do want to talk a little bit about a couple of things. First of all, this year marks the 60 years that Community Action has been working to address and prevent homelessness, address homelessness, poverty, and uplift some of the things that took place in the 60s out of the war on poverty and the war on racial and social justice. And we're still having this conversation, right? And as was mentioned earlier, and my concern is we sit here and you all see me up here, right? I advocate for these things a lot. We advocate for more funding. We advocate for this on the federal level. We're doing it right now. So as we have this conversation today, a few things I have heard more than once are, where are the services? The services are not showing up. Some of the other things I've heard are misallocation of funds, et cetera. And I want to give a little bit of perspective to that. First and foremost, you've all heard me say how taxed our services are and our systems are. And that's just from my network. That's not including some of our peers in the back here. We can't get to everybody. And our funding is continually being changed, cut, further restricted. There is no misallocation of funds. We don't have enough. And furthermore, we are happy to get out there and outreach and connect. We are swamped at our doors with the people we're trying to prevent eviction and prevent homelessness before they're in those encampments and before they're out. And again, that's not discounting some of the things that happen with the safety What we also learned in our 60 years is when people can't meet their basic needs, they get pissed off. Because why me? Why me? And if anybody's ever been in that, even from paycheck to paycheck, you feel that. And so it's no surprise that we're in this mess. We did it to ourselves. And I want to echo Jasmine in saying that we need to come together. This is a start of the conversation, and we need to figure out how to solve it, but there's no one layer. We've got to walk this back. There's public safety way to solve this. There's also, how do we get the local entities to connect with people like us, but we don't have the capacity to get everywhere. With that, I'm happy to answer any questions.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next opponent. Welcome.
Thank you. All right, my name is Matthew Tracy, MATTHEWTRACY. I am a Housing First case manager, one of the programs that funds have been misallocated, apparently. As a human service professional, I have an ethical obligation to advocate for change in regulations and statutes when such legislation conflicts with ethical guidelines and/or client rights. LB 1357 is discriminatory legislation attempting to criminalize homelessness. LB 1357 is not a viable solution for several reasons. It's ineffective. Criminalizing homelessness does not address the root causes of homelessness, such as lack of affordable housing, mental health issues, substance abuse, or unemployment. Instead of solving the problem, it merely pushes individuals experiencing homelessness in the criminal justice system without providing meaningful support or resources. It is also a violation of human rights. Homelessness is often a result of systemic issues and personal circumstances, and punishes the individuals for the lack of housing is a violation of their basic human rights. Everyone deserves access to safe and secure housing, and criminalizing homelessness further marginalizes already vulnerable populations. LB 1357 continues the cycle of poverty. Criminalizing homelessness can perpetuate a cycle of poverty by imposing fines or penalties on individuals who are already struggling financially. This can lead to further debt, legal issues, and barriers to accessing housing, employment, or social services, making it even more challenging for individuals to transition out of homelessness. LB 1357 also lacks alternatives. Homelessness does not offer viable alternatives for individuals living on the streets. Instead of punitive measures, investing in affordable housing, mental health services, substance abuse treatment, and social support programs can address the underlying issues contributing to homelessness and helping individuals rebuild their lives. Will have a profound community impact. It will strain resources within the criminal justice system, law enforcement, and emergency services, diverting attention and funding away from more effective solutions to address homelessness. And it can also create tensions between law enforcement and those individuals, and it leading to further stigmatization and distrust. Many people are experiencing homelessness will choose jail in lieu of fines, increasing the population of an already overcrowded jail system. It also reinforces stigmatization and discrimination. Criminalizing homelessness reinforces negative stereotypes as stigmatizes individuals who are homeless, further isolating them from society and hindering their ability to seek help or support. It perpetuates discrimination and marginalization, making it harder for individuals to reintegrate into their communities. Thank you for your time. I'd be happy to ask questions.
Thank you. Any questions from the committee? Seeing none, thank you for being here today. Next opponent. How many more opponents do we have testifying today? Thank you.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Jason Feldhaus. That's JASONFELDHHAUS, and I am the Executive Director of the metro area continuum of care of homeless, or MATCH, for both Douglas and Sarpy County. I provided some written testimony, and I think with the testimony we've had here today, I will kind of work through a couple pieces of mine, but generalize some of the questions or some of the information back to you guys from some of the questions I've heard. One of our concerns with LB 1357 is that we proceed, HUD provided us $5.8 million this last year in our no-foot process, which was $453,000 above the year before. If we go to criminalizing, or the state would start to put in criminalizing bills, we are at risk of losing a portion of those dollars, and especially some of those new dollars that we received. HUD looks at, as it was mentioned earlier, as housing first as one of the best practices that we must adhere to as a COC. In addition, MATCH and the local COC are actively building strategies. MATCH is currently hiring a street outreach coordinator to manage and increase efficiency at the street level. We're working to increase off-hour response teams, share training practices, and work with local law enforcement. In 2023, MATCH opened up the position to the Council Bluffs Police Department, so that on my board, there's a police officer that's advising our work. We've added a summer pit count to increase our data component and being able to understand the seasonal changes in the population size that we'll be working with in the Omaha community. And in October, we will host a new event, Project Connect, to target unsheltered individuals prior to winter. I think it's important to know that the COC isn't just sitting around, or as what was said, allowing people just to encamp or live in tents. Our service providers on a daily basis are going out and meeting these individuals. I also think it's a miscalculation to say, or categorization to say, that no services are provided. Services are provided through street outreach teams, and you'll probably hear from many of them on a daily basis to individuals with the encouragement to participate in those services. There was a statement about individuals that choose to not enter shelters or enter shelters. And I think one thing we have to understand with the population that we're serving is the building of that trust in order to take advantage of those services. They've been in and out of services almost their whole life, whether it's the Department of Health and Human Services, our medical services, corrections, probation, etc. Our homeless services are, in many cases, the last stop on the train. They've already gone through most of our other social services. And so the individuals that apply every day their effort to support people should be recognized, and that services are provided on a regular basis, but trust has to be developed. I will stop there and take any questions that anybody have.
Any questions? Senator McKinney.
Thank you, Chair Wayne. Quick question. Is it your opinion that individuals who may not want to go into shelters don't want to go into shelters because they want to break the law?
Absolutely not. Like, I guess how I would come at that question is this way, is that first off, they have every right, as we do, to self-determination on what's on their best half, right? And if we legalize it in that it's a mandate, then you've taken away their self-determination on what is in their best interest, I think is one part of it. Two is, between 2019 and 2023, we saw in 2019 about 7,577 people individualized in our homeless services in around the metro area of Omaha. In 2023, we saw 7,111. So we actually saw a slight decrease there. But what I've seen is an increase in unsheltered. So 2019, there was 46 people accounted for in the pit count. In 2023, there was 210. And our chronic numbers have gone from about 32% of the population to 40% of the population. And so what I think we're starting to look at is we have to adapt some of our strategies we currently have to address the new population needs that we're seeing. And shelter as a standard service is still a valuable strategy, but we're going to have to figure out how we identify the actual strategy to the individual on the street to encourage that uptake. Whether shelter alone isn't the uptake or the strategy. So we're really gonna have to try to develop those. Sorry.
Oh, no problem. what would be your response to the statement earlier that there are enough beds? There's either a misusage of funds or a lack of something occurring within the services that are supposed to be available.
So there's some validity in that statement, in that I'm running at about 85% utilization in my shelter system. So I have about room for about 15%. But what we're realizing is that the populations that are increasing that we're seeing in homelessness are 55 and older. And we're also seeing a lot more with dependent children or families. Our shelter system wasn't developed originally as a strategy to address those populations. And so I think there's an adaptation we have to go through at making, if shelter is a temporary solution, that's more accommodating to those populations. I just think right now we're in a stuck strategy. Like what used or worked before 2019 obviously is not working now, and we're seeing trends that are shifting. Affordable housing is part of this conversation, mental health, all those pieces, but also adapting our service delivery system at the street and in our community is necessary, and we're just starting to see those trends coming out of the pandemic, if that's helpful.
All right, thank you.
Any other questions? Seeing none, thank you for being here. Next up on.
I can't hear what you're saying.
No, we can only have one, because they're transcribers, you can only have one person to talk.
So my name is Jeremy Follen, JEREMYFOLLEN. I kind of wanted to touch on a subject that hasn't been brought up yet.
Sir, can you talk just a little louder?
Sorry. Yeah, I wanted to talk about something that hasn't been brought up yet. 2 days ago, a friend of ours passed away because he wasn't allowed inside the shelter. Because one, he was a gay man, and two, because he was diagnosed with AIDS, and they don't have the support system that we need. Some of us aren't out there by choice. It's because we have no choice. And when they say there's no free spirits, everybody that lives in the encampment that I do, we are a family. We all have the help from the church that helps us. We have anybody we need. Somebody's got resources somewhere. And as hard as it is to admit, yeah, I've made my mistakes. We all have. But I don't feel like passing this bill and penalizing and criminalizing our efforts to try to do better is going to do us any good in trying to change who we are. It's just going to make things worse. That's all I have to say about that.
Thank you. Are there questions? Senator Boswell.
Sir, I noted that an individual wanted to come up with you. I don't know if you were in here when he said, but she can sign a gold sheet and say that she echoes your comments if she would like to be heard on the matter.
Yeah, she's got some other things to say as well.
Oh, okay. That's it.
Any other questions? I don't see any. Thank you. Next opponent.
Hello, y'all. How you guys doing?
Can you just pull that microphone a little closer and speak up just a little bit? Yeah, it doesn't go far. It's the
You hear
best
me
we
now?
can do. Thank you.
My name is Ariel, Arielle Nichols, Nichols. I am 32 years of age. I currently live at the encampment of 15th and Izzard. We have several people here who we've lost over the last year due to elements. The elements will kill you faster than anything else will. But these people all died on the Francis House lawns. 5 individuals we lost in our community, all of our family members. If you make this law here, we're forced to hide, go further from our resources, which all we have is right there. We get tremendous support from the community, from individuals who drop off food, who drop off firewood. We have one guy who dropped off pop and everything we needed in that one corner, which is all we have left. Every time we go someplace, there's no designated place for us to camp. So they shove us off, they make us move, so we do so. We don't want heat from the police, we don't want to cause nobody's strife, we just want to live in peace. As members of this community, we are treated less and less like people. There was a woman that I was very close to. She became like a surrogate mother to me. As somebody who grew up without parents and in the state's care, I learned to survive on my own. This woman took me under her wing. Her name was Dawn Nordstrom. She was a victim of an assault. She was raped and given what's called a hot shot. That's where they give you a mixture of usually meth and fentanyl, and it goes into your vein. It kills, stops your heart. For her, this was done improperly. Getting the cops to listen to her or getting them to do anything about this was an impossible task. We deal with so much on a daily basis from our community. People are supposed to help us. Nobody ever knows this. Getting somebody to listen to you, like the police or medics even, when you're at risk like that, it's the hardest things. They don't listen to you. They think because you're homeless, you're drug seeking. Not all of us are addicts. Not all of us have ever done any drugs. A lot of them are, a lot of us are, but not all of us. So you cannot classify us as one whole person or one group. We're all individuals. We all have a story. The reason people stay in shelters is because it's dangerous. At the Center, for instance, I stayed there for 2 years. I saw on average 3 or 4 stabbings in a week on campus. I witnessed one of my best friends there get beat to death. He didn't do nothing wrong. And getting them to even do justice for him was impossible. We all have to become medics of our own because getting basic things like medical care, a lot of times is really difficult. They don't hear you. I went in, I had a really bad infection in my legs from poison ivy. It took 4 round trips to the ER before I finally laid on the church lawn and was dying of sepsis before I even did anything. And it's only because somebody else fought for me. That person's no longer here. Thank you.
Thank you. Take our next opponent.
I'm Annetta Verdarte. It's spelled ANETTA-RODARTE. I am 60 years old. I currently live at the Sienna Francis house, but I get so stressed out in there because people talking to themselves and hollering. So I've asked them to move me, and they've refused to. I have to go out to maintain my sanity. I have to go out and live in the street. And I went, stayed out one night with a friend of mine. He got to go back into the shelter and get his same bed. I had to sleep on the streets, on the curb for 4 days in the cold. And I'm 60 years old and I don't understand this. I could pay, I had my own apartment. It was in the city view. And Together Incorporated helped me get it, but someone shot a gun off in my apartment, so I got evicted. And now they have this housing thing where they randomly pick people to go into it. I've been sitting there for 3 years and I still can't get a home. And I can pay for my home, but I can't pay for the rent as well as the utilities. And I wanted that known.
All right, thank you. Let's see if there are questions from the committee. I don't see any. Thank you so much for being here today. Let's have our next opponent testifier.
Sit. My name is Chrissy Gallagher McMillan, and this is Chewbacca. Good boy. I live in one of the tents by Holy Family's name in Omaha. I've been on the housing list for 3 years. I have been working with the outreach case managers, including the church. I am actually on the housing list for one of the tiny homes that they just built. I'm just waiting for one to come available. I have been fighting with the shelter won't let me or him in because we were in there at one point and a lady decided to keep pulling him on his ears and he snapped at her. But they're real quick to blame him. I have epilepsy, stress-induced seizures. I have a lot of other medical issues. So being without him kind of really makes it worse. So we choose to stay outside. not all of us are as dangerous as people think we are. We're really not. I'm just trying to get into housing, and it's just being a waiting game. And excuse me. We are discriminated against in the shelters as well. They're saying, you can check in, but when we go to check in, we can't check in. We are mandatory bottom bunk. And if there's no bottom bunks, we're outside regardless. Buddy. Thank you.
Thank you. Let's see if there are questions from the committee. I don't see any. Thank you so much for being here.
Come on, bye-bye.
All right, let's have our next opponent.
My name is
Welcome.
Peggy Gerling. It's Peggerling. I'm 65 years old. I came to Omaha in May of 2023. I have been homeless the entire time I've been here. I started off at Siena Francis. My life was threatened, and I was poisoned. And I resorted to staying with my granddaughter in a tent until I could get into my own tent. And we have been ridiculed. We have been basically ostracized. I've tried to get a bottom bunk to try to go back because it was getting too cold. And I'm not allowed back in there because certain staff members don't like me. I'm a troublemaker. I open my mouth when something goes wrong. I can't stand people being used and abused. And there's other people in there that get a chance to take your things and never get reprimanded. It makes no difference. If the staff likes you, you're in. If they don't, you're out. It's that simple. Yeah, I didn't choose to be homeless. My fiance died because of COVID. And that left me with more bills than I could ever pay. I lost everything. And my children brought me here to this state because I'm not even from here. I'm from Missouri. I don't belong here. But because of everything that you've got to go through to get on your feet after everything's been taken, I can't go through all the proper channels. I don't have the facilities. I don't have any of the resources that I need. And it's taken me a year to get this far. And I'm holding on by the skin of my teeth. That's it. I just hope they don't criminalize this because that's not helping anybody. It's not criminal to be homeless. It just makes it worse if they do this. It'll give everybody a criminal record, and that's going to make it impossible to get a job or a home. Thank you.
Thank you. Are there questions from the committee? I don't see any. Thank you so much for being here.
Hi.
Welcome.
Thank you. I am Jill Lynch Sosa. It's JILLLYNCH-SOSA, and I'm the executive director for the Society of St. Vincent de Paul. All of this, the 6 people that just testified were in the tents half on our property, half on the sidewalk. That's caused a little bit of a debacle here lately. And I'm not gonna get into statistics and all this. I am not a political person. I feel like I kind of got pulled into this a little bit, and I really feel like I need to stand up for those that were camping on our property, half on, half off. First off, I want to say, Senator McDonnell, I have so much respect for you and all of the senators. You have hard jobs. I get that. I know you do a lot of great things for the city and you believe in this. And I get that and I applaud you for trying to come up with a solution. My own personal opinion is this is so wrong because I know the people it affects. I'm not representing the people that it affects. I know these people. I spend every day with these people. I go outside and yes, they've been camping since November on this strip alongside our building. And it was a core 12 and we had an agreement and they stuck to the agreement. We know it's not a long-term solution, but it's a dignified way to help them when they don't want to go somewhere else for many reasons that you've already heard. When we say they don't get any help in the tents, that's not true. They get so much help in the tents. That's why I wanted them close because it was a bitter winter. We all know that. I wanted to make sure they had a place they could get inside and that they had help. All of our service providers, they know where to find them. If we push them further back, it's more dangerous. It's harder to get to them. People won't know how to help them. And 211, when we talk about 211, you know, most of our requests come from 211. They come to us to say, hey, can you help these people stay in their houses so they don't go into homelessness? We got over 4,000 calls in January. And we are funded by the grace of God of everyday people, not the church. We're not the church. We are not governed or funded by the church. We are independent. We're a charity just like anybody else. And there's only so much we can do, but we do want to be there. And for Mr. Trivedi, I totally feel for him. I get it. But when he says that that SSVP is dismissing them all now that it's gotten out of control, that's not true either. I don't think any of these people that I brought up here feel like I dismissed them. I'm trying to help them move forward under the circumstances that we have right now. So I'll take any questions if you have any.
See if there are questions then from the committee. I don't see any. Oh, hi, boss. Thank you.
Thank you, Madam Vice Chair. Do you feel like you will ever have too many do you ever feel like the population will grow to a place where you can't accommodate them?
Oh, absolutely. Absolutely. The problem is they aren't the problem. It's the resources. It's housing. Right. Our core mission is to keep people from falling into homelessness. But we also have this group of people that are around us and we are obligated to help them. That's our mission. Yeah, I'm scared to death about that. But criminalizing the situation only makes it even harder. We had a situation where 12 of them got pulled out of their tents in the middle of the night and arrested. Now, normally what would happen is someone would come, bulldoze all their stuff, throw it away. They'd wait a few days, who knows, before they got out. We were able to work with the city and the police department and the city prosecutors to get them out of jail, but we also had to have people watching their stuff. 3 dogs got put into the Humane Society. We paid to get those dogs out. They couldn't have done that. 1 person got their car towed. We never got that out for them. It created not only stress and difficulties there, but more financial crisis than they're already in. The trauma of that, people are so, and I'm jumping now, but people are so mean to them. I mean, I've been out there when they've shot BB guns at them or thrown firecrackers at them just because they're homeless. They're just trying to get by. But yeah, is it going to grow? Is it somewhat out of control? It is, but it's not their fault. We have to have housing options. We have to have better resources in the community. We have to be able to help them find some jobs and give them some coaching so that they can be successful. But criminalizing them is not the way forward, in my opinion.
Okay, thank you. Thank you, Madam Vice Chair.
Other questions? So I have one for you. And I missed part of the hearing, and I'm very sorry about that. I had to go to another. Some folks mentioned the housing list. Is that your housing list that they were talking about?
No, we don't. They've been on the housing list for tiny homes, the housing lists. I honestly, I don't know what all of them are. They work with together, they work with different agencies.
And there's apparently not enough of those housing options.
Some of their challenges is they have to have their IDs, for example, like Chrissy, who's waiting to get into the tiny homes. She needed to have IDs, but she had her IDs stolen at one point. To get IDs, you gotta have an ID. You have to get out to the Social Security office. You have to have money to pay for the stuff and all these different things. And it was just barrier after barrier after barrier. And we helped her so that she could get these things done. And so now she's got her IDs. And when I say we helped her, yes. But everybody behind us, everybody helps. There's more than enough for all of us to do because there is so much need out there. But in this, it's just one thing after another for them.
Okay, thank you. Any other questions? Thank you for being here.
Thank you, guys.
Take our next opponent.
Good afternoon. My name is Leanne Pelser, Leanne-Pelser. I am the Director of Housing and Outreach Programs for Matt Talbot Kitchen and Outreach. We're located here in Lincoln. We're dedicated to relieving hunger, defeating homelessness, addressing addiction, and providing outreach. I prepared this testimony that's in front of you, but I'm not actually going to speak on it. I'm going to answer some of the questions that you've been asking. The question about the housing list. So for programs such as ours that gets funding from the COC, we are mandated that we have to take from coordinated entry. Coordinated entry is a centralized way of folks who are experiencing homelessness. They will do a common assessment that everybody does. They get put onto this coordinated entry list, and then they're taken off of the list based on vulnerability. If you have really high vulnerability, meaning you have a lot of risks in your life going on, you might have health problems, mental health issues, addiction, etc., have been having a lot of interactions with the police or going to the hospital, you're going to have higher vulnerability, needing more case management services for those permanent supportive housing spots. With those permanent supportive housing spots, there's only a few because they're permanent. So somebody has to graduate from the program or something else has to happen for a place to open up for them, which then delays those folks who are vulnerable in being able to get into those units. Then you have the people that don't score that high, who maybe it's their first time in homelessness, or maybe their second, but they don't have all of the risk factors. There's not enough programming out there that is allowing them to be able to get into rapid rehousing or having that first month's rent deposit a few months. There was during COVID, there was a lot of money, but there isn't anymore. And with that, that means their trauma goes further the longer that they're homeless, and that adds to the people that are needing those higher spots. The more, instead of making being homeless a criminal action, there needs to be more resources for those who are just entering into homelessness and for prevention. We spoke to our guests about what this bill meant, and I just want to share. They said, "I'm not sure where I'm supposed to go. I can never get into shelter. I already feel like I'm invisible. We need more shelter space. It's not our fault, but there's never room for us. We have to be somewhere, and it's safer for me to be downtown than out in the middle of nowhere. It's less likely that I'm going to be attacked. We need more shelters. You can't put someone in jail for being homeless if they have no other option of where to go." Thank you.
Thank you for your testimony. Let's see if there's questions. Senator Bosnick.
You said something at the beginning and I didn't catch the word.
Sure.
You said, in order to qualify for a subsidy, essentially, you have to utilize the what?
Coordinated entry. So us housing providers have to take individuals off of the coordinated entry list.
And that's where the risk level
Mhm.
factors come in, that essentially if you're not high risk, high needs, you're never going to bump up.
Right.
Is that what you're saying?
Yeah, so it's based on so what happens is if a housing program has funding, such as ours, we have to take the first person on the list that's for our subsidy. So the first person for a permanent supportive housing spot would come off the list and come to us if we had rapid rehousing dollars, which we don't right now. But when we did, it was the first person on that rapid rehousing scoring. So it all depends. We don't get to choose who we take. We just take the next person. So what happens is it's not a time. So you could do the assessment today, and I could do the assessment today. And she could have done it 2 years ago, but we could be needing more help than she does. So we bump over her. So people can be on the list for a really long time.
Thank you.
Are there other questions from the committee? So, am I understanding you correctly that one of the big sort of system-wide problems is that it's this initial entry into homelessness that if not sort of provided a solution with, that things sort of escalate in terms of difficulty to get home, home?
Yeah, so what's happening, and there's a lot of research that's being done, and Lincoln is working on doing diversion kind of in a different way in prevention of trying to prevent people from becoming homeless in the first place, or to shorten their time of becoming homeless. And there's not enough dollars at that level because all of the focus, which rightfully so, is focused on the people that are the most vulnerable, which is great. There's just not enough because those spots move very slowly and there's not enough affordable housing out there that I could take Jimmy, who doesn't need a lot of support but only gets $941 a month from SSI. I can't get Jimmy into a studio because there's not enough dollars to help him with that. There's just not enough for folks who only get disability, who only are working a minimum wage job, and for families who maybe have 4 or 5 kids and only one parent is able to work because of the cost of daycare. It just doesn't, the cost of rent compared to the cost of living is just not feasible.
So, thank you. That's very helpful to understanding some of the other work we do in this committee as well. And then I heard you say we need more shelters. I think several people, because but then I know the proponents were saying there's plenty of shelter.
So
is it just that we don't have the right shelters? Is there not a matchup of shelters? What, can you elucidate that?
Sure. So here in Lincoln, we have one shelter for that. We have, a shelter that's for domestic violence, but that's different. We have one shelter that's specifically for folks who are homeless or families. There's only one. But there's 492 people from last year's point in time count that were homeless. That's not they don't have 492 beds. And if you don't have an ID when it's not freezing cold out, you can't get into the shelter. And if you come here from Beatrice, like something's happened and you've come here from Beatrice, and you're here and you're stuck here, and you can't go into that shelter because you're not from Lincoln and you don't have a Lincoln address on your ID. So then you have that person that got here for whatever reason they came here from Beatrice, let's say, and they can't get into shelter, and then they're having to do what? They have to sleep somewhere. and they have no other option but to sleep outside. And that the quotes that I was saying were from our guests that walk through our doors every day, who come in and have meals and have access to showers, but they still have to sleep outside because they can't get into shelter because there's just not enough beds.
That is the experience I had once when there was a woman who walked into a class I was teaching at a church who was homeless, and we were trying to find a place for her to go to. And it was later in the evening, so, 8 o'clock something. And so we didn't know how to find her a place, and everybody was apparently full.
Yeah.
Is that a common experience?
It is very common. And, the shelter here in Lincoln is great when it's cold. And by cold, we mean like 14 or low, like really cold. They will make accommodations, and you can call and say, can you take somebody? And they'll say, yeah, but there's 150 guys sleeping on the floor on a mat. So just let them know. If I've experienced trauma, I'm not going to want to go sleep on a floor with 150 people. I'll be afraid. It's not, or I have schizophrenia or any other thing going on, and you're going to put me on the floor with 150 people. That's scary. I mean, strangers, it's just, there's just not enough of anything. And I heard the proponents talking about how there is, but the reality of it is maybe they're talking about the whole state, and maybe there's beds available in other places, but then you're talking about sending somebody from Lincoln to Western Nebraska without transportation, without community, without anything. So how is that helpful to the individual?
Okay. Are there any other questions? Thank you so much for being here. Next opponent. I'm sorry, ma'am, there's no props.
Good afternoon. Thank you for this opportunity. We need to do this. We are really grateful to have this opportunity to hear the people that already spoke. And my name is Lily Reyes, spelled Lillyreyes. I have been working as a conference support in San Vincent de Paul Society. And I have this beautiful opportunity to meet these people, that they already there, some of them, but to meet people like Chrissy, to understand what is the difficult situation that they have to handle every single day. It's not about options, and we hear a lot about this, but when you meet the people and you hear the history, you realize that they are handled with a lot of difficult situations, with a lot of mental illness, because some of them, they went through impacting situation, like they lose an important person in their life, they lose their houses, and you have to understand that it's really difficult to stand up by with this kind of problem. I met some of them, and they was in the street, and we start to build this relationship with them, to help them with little things that they need to go over with their life. I have one co-worker now who was in the street. We start to talk with them about build their own confidence again, to trust on somebody. It's difficult because no one wants to trust on people who was in the street with some record, with some problems, but he's working now with us. And he couldn't be here because he have another issues now with her health, but we don't have enough with the system that we already have. We don't have enough money to address the whole difficult situation that they are suffering now. And to convert their life as a homeless, to a criminal, is not help at all. It's not gonna help at all. It's just contributing at this kind of circles. When they are going to go off of the jail, they don't have any other options. So.
Thank you for your testimony. Let's see if there are any questions. I don't see any for you. Thank you for being here. Next opponent. Welcome.
Hello, good afternoon. My name is Casey Lopez. I'm a constituent of District 11 in Omaha, Nebraska. I'll begin by expressing gratitude to each and every member of the committee for welcoming public comment on this important issue. I believe everyone in this room today, regardless of the position they speak from, is here because they want to see a positive change. I stand before you as a Nebraskan who up until 7 years ago slept many a nights out in the cold with the hard concrete against my back. My dysfunctional on and off relationship with homelessness began over 20 years ago, starting with the domestic violence situation. I spent most of my life struggling with addiction and mental health. Today, I'm very proud to say that I have 6 years in recovery. I'm the supervisor of a crisis diversion peer support program. Currently, I sit on several advisory boards and want to implement change within our housing system. Before I found recovery, when I could be described as street homeless, I felt absolutely worthless, invisible, like my entire existence was inadequate. Most days, I walked the same 13-mile loop through the city until my feet and my spirit gave way to exhaustion. In those years, I was a person who would have been greatly affected by LB 1357. During that time, I experienced constant waves of shame about how I looked and smelled. I tried to hide from the world. I was so afraid of people. While emergency shelters offered me assistance on numerous occasions, living in the shelter wasn't always possible for me. Sadly, due to the state of my mental health, my addiction, and trauma, shelters were not always an environment that I could put myself in. At times, shelters were more triggering to me than sleeping outside. After many years and many attempts, I found recovery and stability. Agencies like the one I work for today helped me to disrupt and eventually break the cycle that I was stuck in for so many years. Today, I have a passion to serve others and want to help people in the same situations that I was in. Every day, I wake up having the privilege of supporting people through homelessness, addiction, and mental health disorders into a life where they can thrive. It is my strong belief that our homeless friends and neighbors should be supported. Housing is a human right. I have no question that this bill has the potential to further damage criminal records and drive people deeper into poverty. For those who live outside, homelessness is traumatic enough. Individuals are just trying to survive. Unhoused people already worry about danger, hunger, extreme weather, and violence. To add LB 1357 to their worries is unjust. I am very concerned about the hopelessness this bill will create, and that it will drive folks away from integrating into our social fabric, that it will endorse a belief of being left behind or forgotten. In order to house people, we have to show that we're invested in them and that we care. We have to build trust and show that they matter. In closing, as a person who has overcame homelessness, who currently works with the unhoused population, I stand before you as living proof that with lots of support and resources, even when you're outside, change is possible. Today, I am asking you to make a positive difference in someone's life by voting no to LB 1357. Thank you.
Thank you. Let's see if there are any questions. I don't see any, but thank you so much for your testimony.
Thank you.
Our next opponent.
Hi, my name is Pete Miller, P-E-T-E-M-I-L-L-E-R. Thank you for giving me this opportunity. I've been a proud member of Omaha's street outreach team for 13 years. And during that time, I've also worked as a housing case manager, helping folks get off the streets into their own places. As anyone who works in homeless services can tell you, two of the biggest barriers to getting housing are criminal history and lack of money. So the idea that you can reduce homelessness by making it a crime with a monetary fine? It defies logic. Unhoused people are not the problem. Homelessness is the problem. A lack of affordable housing is the problem. A lack of treatment beds for people struggling with addiction is the problem. We don't have enough psychiatrists or therapists. We don't have enough shelters for women or children or couples or people with dogs. We don't have enough nursing homes or permanent supportive housing. This legislation doesn't even pretend to address any of those issues. What we do have is a committed team of outreach workers who are on the streets every day, working hard to build the relationships that can help us address the tragedy of people living and dying outdoors. Those relationships take time. Unhoused folks need connection, not criminal charges. They need support, not traumatizing police raids. They need permanent, affordable housing, not jail cells. This law, if passed, will only make it harder for our neighbors on the streets to trust the systems in place that can actually help them. And having criminal charges on their record will only mean they're on the street longer. Although I do believe the proponents of this law, they have good intentions and think tough love can solve this issue. I also think it's those proponents that need tough love, need to hear the difficult truth that they can't arrest people out of homelessness and can't just send the police to hide the problem from public view. Solving this issue requires funding low-income housing, laws preventing landlords from discriminating against people with housing vouchers, well-funded legal assistance for people facing evictions, spending real money on mental health services and treatment beds. It requires speaking up for the dignity of our neighbors, your constituents, who have the least, even if they're not popular. Tough love means making hard decisions towards real solutions, not the cruelty of LB 1357. Thank you.
Thank you for your testimony. Are there questions from the committee? Don't see any. Thank you so much for being here today. Next, opponents.
Hello, I'm Sarah Hughes, S-A-R-A-H-H-U-G-H-E-S. I will start by just noting that it was really disheartening not to hear anybody really talk about housing being a solution to this problem on the people that were bringing this forth. So I just want to make sure people know that housing is what is needed. Also, just let you know that there are services brought to people's tents. As a street outreach worker for the last 14 plus years, I've had the pleasure of meeting a lot of our unhoused neighbors in Omaha and across the state of Nebraska by going to their tent doors, going to their homes and asking them what they need. Sometimes they're not ready to engage in services, but that's when we continue to come back and offer them services. The services we offer are everything from housing to health to getting them documents and getting them housing ready. I'm part of Omaha's point in time count every year. And someone did mention that we had 312 homeless individuals in Nebraska last year on our point in time count. That night it was in the upper 20s. So people have to live in that weather. And as you know, about a month ago, it was negative 44 and about 3 or 4 people behind me. And I went out and tried to engage with those people that were still sleeping outside when everybody else was at home in that nice heat and everybody else was out negative 44 wind chills. We also need to think that we can all agree that we want to end homelessness and we want Nebraskans to live in safe and affordable housing, but arresting, convicting, and finding someone for being homeless is not going to help that problem. It's going to make it worse. Most of anybody I've ever met that was unhoused wants a home, but there's barriers to get it. Criminalizing homelessness will make that housing further. Landlords will not take somebody with a criminal background. There's not enough housing stock. So a landlord can pick somebody that doesn't have a criminal background and pair somebody that does. And criminalized homelessness will not end it. It'll prolong it and add to a list of barriers. These kind of laws traumatize unhoused individuals. They're dehumanizing and they have a negative effect on someone's health, physical and mental. And telling people to go to shelter doesn't work either. Most nights the shelters are full and are not able to accommodate persons with needs with wheelchairs or with pets or LGBTQ. Us on street outreach would rather educate our community on the appropriate response to someone that is unhoused and sleeping outside. I make that a mission to educate our community about how to treat the unhoused population and not by calling 911 unless it's a major emergency. Area police should be using their resources to engage in true crime and engage with homeless services and street outreach to get them to engage with those sleeping on the streets. Also, when camps are raided and such, people's IDs that could take months and months to get are also lost. That will keep them from not getting in housing as well. I did put a couple of supporting documents in here. One of them is the current street outreach flyer that we help people with resources. Just wanted to let you guys know if anybody here wants one, they can reach out to that number and we can email you the PDF if you have it in your community for the Omaha metro area. That is Sarpy and Douglas County and Pot County. Thank you. Any questions?
Thank you for your testimony. Other questions? Senator Ibach.
Thank you, Madam Vice Chair. I just have one question.
Yeah.
Help me understand what a solution to the business person that testified first. What would be a solution?
I would love for street outreach. I helped start the street outreach with the gentleman that just spoke with me, to have the opportunity to go meet with him and sit down and talk with him, to see what his issue is. I love working with the Downtown Improvement District. I'm good friends with one of the people on the board, so I'm going to reach out to her in regards to that as well. So we can get in front of this gentleman and talk to him about what we could do and how we can talk with our folks that are out there. This is the first time I've ever heard of this issue happening with that down there in that area. We are down there almost every day engaging folks. Not everybody wants to be engageable, but I would definitely want to have that conversation with him, with street outreach, to see what solutions we can make, and then have us be that lifeline for him and give him some of those tools. Because it's not good. I mean, that's not good for a business people to get harassed and stuff like that.
Okay, thank you.
Yeah.
Thank you.
Thank you, Senator Ibach. Other questions? Thank you for being here.
Thank you.
Next opponent. Welcome.
Thank you. My name is Melissa Neuenfeld. It's MELISSA-NEUENFELDT. I'm a registered nurse. I live in Omaha, Nebraska. My zip code is 68114. Thank you, Senator DeBoer and the committee for letting me testify. I'm not going to read my testimony because it's repetitive of much of the other testimony. I do want to tell you that I forgot my reading glasses as well, so that's helpful that I'm just going to go off script. One thing I want to say, well, I'll tell you why I'm here. I work in direct patient care in an inpatient psychiatric hospital in Omaha. I have also practiced nursing in emergency departments and in hospice in my 27-year career. I had an experience with an emergency department patient that led me 8 years ago to become a volunteer on the street outreach team, and that's indicated in my testimony. But the voices of actual people who are living the experience, I think, spoke to what I wanted to communicate. And that is that if you've met one person who's experiencing homelessness, you've met one person. And I think that's a really important key that I don't know that has been actually stated. In addition to working on the street outreach team, I was also invited to serve on the Continuum of Care Board, that's MATCH. I've been a MATCH board member for 6 years and I chair the programs committee. I also am the medical lead for Project Homeless Connect. This is all volunteer work, by the way, I don't get paid for any of it. And I do a few other things in homeless service too. Inspired by this 29-year-old woman who died despite everything that we tried to do to help her in the emergency department. Because what we can do in healthcare is give medicine, but Amy's condition was never going to get better until she got it stabilized in housing. And we couldn't give her keys to an apartment in the emergency department. I did just apply for a grant. I'm designing a new program to help serve people like Amy who are not able to engage in the community resources that are available because of their mental illness, active substance use, and chronic medical problems. So I'm designing a program that's the first in the country. Nobody else is doing this. And I've just submitted my first application for a grant. So there is reason to hope. And I do want to convey that as well. I think we've heard a lot of heavy stuff today, and I want to let you know that there's reason to hope.
Thank you. That's a nice thing to have at the end of a long day of hearings. Are there questions from the committee? Thank you for being here.
Thank you.
Next opponent.
My name is Scott Jackson, SCOTTJACKSON. I work for Heartland Family Service in Omaha, Nebraska. I am a permanent supportive housing case manager. I am not going to read off my sheet here because it's been a little bit repetitive. What I do want to talk about today, senators, is we need affordable housing in Nebraska, and not just in the cities, but across the state. I also want to talk about how criminalizing homelessness is going to be a detriment to the community and to the state, as it will add undue costs to the criminal justice system that's already plagued with overcrowding and other issues. Criminalizing homelessness in the state is going to be a big problem for everyone involved. Now, the service providers like myself work diligently to try and find housing for our clients. My clients face so many odds, a lot of discrimination from landlords, whether they need 3 times their monthly income to make the rent, or they just blatantly say, oh, we're not going to take you, after they run a background check. There's source of income discrimination. There's the fact that we're a housing choice provider, and that makes it difficult for landlords who have had difficulties in the past. Now, I do feel for landlords who have had problems with housing service providers, and I know Senator Vargas last year wanted to pass a solution to help mitigation, because mitigation is a very important part of helping landlords stay working with us. Now, criminalizing homelessness, I think ultimately will really be a detriment, and that it'll make it a lot harder for us to see our clients if they're locked up in jail for 90 days, or if they've got previous criminal history. We can't go into the jails and see them, or if they go off into prison. The criminal justice system is going to get overplagued with some of the issues that we're already seeing. Affordable housing in Nebraska is much needed. Our clients don't have that direct choice and opportunity at times. And like I said, they get discriminated against most oftenly. So I really hope that this doesn't get passed. This is going to be a detriment. And I hate to see our clients get into a position where they can't continue to work with us housing service providers because they're afraid if they're going to get turned into the police or have to go to jail. That's a detriment to their mental health, the trauma that they've already overcome throughout their livelihood. So I'll be glad to take any questions that you may have.
All right, thank you. Questions from the committee? Don't see any. Thank you so much for being here, sir.
Thank you.
Next opponent.
Thank you, Father Keith Winton, Keithwinton. Others have spoken before me today and articulated the economic and social services aspects of opposition to this ill-conceived bill, but I'm here to articulate the ethical aspects of opposition. To tell you something you already know because you live it out every day here. Our duty as leaders in our communities is to work to ensure fair opportunity and access to all the vast riches we have been given, to represent and support all community members, and to be good stewards for future generations. Creating a just society entails fostering social cohesion, promoting human dignity, ensuring that all individuals have the opportunity to thrive and fulfill their potential. Doing this is not a simplistic task, and it involves balancing competing goals and desires. But with that basis for action, to choose a simplistic solution to a complex problem, especially a solution that criminalizes those who are already marginalized and without basic resources, is to abandon both our duty and our foundational ethical principles. Our dedicated and self-sacrificing police force should not be used for this purpose, when those with better and specific training are more appropriate and effective. When a homeless person is jailed or cannot pay a fine and has a warrant issued, the subsequent record becomes yet another obstacle to finding secure employment and housing. In the end, this bill may be more expensive than doing the difficult work of finding real solutions. There was talk earlier about a three-legged stool. There is currently no three-legged stool. This bill does not create a three-legged stool. It creates a pogo stick to push down people who are already at the bottom. Homelessness is a complex problem, and it clearly seems that we need to do more to address it effectively. But as Human Rights Watch says, criminalizing homelessness does not solve the problem. It makes suffering more brutal and drives people living on the streets further into the shadows. John Stuart Mill in Utilitarianism says, poverty in any sense implying suffering could be completely extinguished by the wisdom of society combined with the good sense and generosity of individuals. And I pray that we will seek to use our wisdom, our good sense, and our generosity to address this problem. Please do not support this bill. Nebraska is better than this. Thank you.
Thank you for your testimony. Are there questions? Thank you so much for being here. Next opponent. Welcome.
Well, thank you. My name is Benjamin Marquardt, BenjaminMarquart. I am here from both, I have personal experience of being homelessness, and I worked in the homeless services. I was coordinator at Stevens Center for a little over a year, and I currently serve on a board for a new nonprofit. It's called Reimagine Omaha, and I am a contracted trainer through that doing Hope Science. Most of what I had prepared has already been said numerous times. There is one thing that all people that are unhoused have in common besides the lack of housing, and that is trauma. And I think, I know that sending somebody to jail when they're already dealing with numerous amounts of trauma will just compound that trauma and add more trauma. The only thing that can truthfully help people is hope and compassion and empathy, and putting people in a cage and taking away any type of freedom of their own meal, freedom of where they sleep, freedom of everything will only compound any issue that they already have and will not help the healing that is required to actually progress past whatever they're dealing with. It is not, and obviously it's going to be a taxpayer problem, and it's just going to compound everything and make it worse and add more trauma to people that are already traumatized. And that's about it.
Thank you for your testimony. Are there questions? Thank you for being here.
Yeah.
Next opponent. Welcome.
Thank you, Senator DeBoer and members of the Judiciary Committee. My name is Casey Ogle, KaseyOgle, and I'm a senior staff attorney at Nebraska Appleseed for Collective Impact Lincoln. Nebraska Appleseed is a nonprofit, nonpartisan legal advocacy organization that fights for justice and opportunity for all Nebraskans. Collective Impact Lincoln is a partnership between Nebraska Appleseed and Civic Nebraska that works with residents of 6 Lincoln neighborhoods to build community, develop neighborhood leaders, and take action on policy that is responsive to their needs. I'm here today on behalf of Collective Impact Lincoln in opposition of LB 1357. Collective Impact Lincoln advocates for better housing quality, more affordable housing, and fair rental practices for low-paid Lincolnites. And we oppose LB 1357 because of its unmistakable cruelty. LB 1357 would criminalize sleeping on public lands unless the property has been designated as a campsite by the relevant political subdivision. This would undoubtedly primarily affect houseless individuals who have no other place to go. And the solution is not to criminalize their attempts to simply survive, but to support the production and preservation of affordable housing. Further, LB 1357 could violate the U.S. Constitution's 8th Amendment prohibition against cruel and unusual punishment. The U.S. Supreme Court has found that statutes that criminalize a person's status violate the 8th Amendment. Applying that reasoning, the Ninth Circuit Court of Appeals has twice found that laws criminalizing sleeping outside on public lands and using materials like a blanket, pillow, or a cardboard box as protection against the elements violates the 8th Amendment. In Martin versus City of Boise, the Ninth Circuit Court of Appeals examined a city ordinance that made it a crime to use public places as a camping site, virtually the same as this bill, LB 1357. Finding the ordinance to be unconstitutional, the court explained that just as the state may not criminalize the state of being homeless in public places, The state may not criminalize conduct that is an unavoidable consequence of being homeless, namely sitting, lying, or sleeping on the streets. LB 1357 would do just that, criminalize the very means of existence for houseless individuals. Such a law is clearly cruel and unusual, and as such violates the Constitution. For these reasons, we urge this committee to refuse to advance LB 1357. Thank you.
Thank you. Are there questions? I have a question for you.
Sure.
The state law 39-312, are you familiar with that?
I was not, no.
Okay.
Can you
so-
repeat it for me?
Yeah, it should be unlawful to camp on any state or county public highway, roadside area, park, or other property acquired for highway or roadside park purposes, except at such places as are designated campsites by the Department of Transportation or the county or other legal entity of government owning or controlling such places. This provision shall not apply to lands originally acquired for highway purposes which have been transferred or leased to the Game of Parks Commission or a Natural Resources District, or to other lands owned or controlled by the Game and Parks Commission where camping shall be controlled by the provisions of section 37-305 or by Natural Resources District where camping shall be controlled. Okay, so would it be your argument that this would also, if tried to be enforced, would be unconstitutional, or is it the fact that it's limiting it to the county public highway, roadside, or other property acquired for highway or roadside park purposes?
I would imagine that if it's not all highway, if it's not all lands owned, I would think there might be a distinction there between like all lands owned by the state or county versus lands specifically designated for highway purposes.
Would the court look at the sort of, I don't know what the whether it's a rational basis test or what it would be, but it would seem there might be a public purpose in preventing people from camping near roadways that they might use to weigh that. Do you know what the standard would?
I do not.
You don't, okay. Yeah. All right, thank you.
Yes, thank you.
Any other questions? Thank you for being here.
Thank you.
Next opponent. Welcome.
Hey. Thank you for sitting through all of our variety of points. My name is Alicia Christensen, ALICIA-CHRISTENSEN, and I'm Director of Policy and Advocacy at Together. We're an Omaha organization dedicated to helping our neighbors experiencing housing and food insecurity. Some of the points on the handout that I provided will, kind of cover some ground that's been covered before. So I just kind of wanted to hit on a few points. I think specifically in the characterization from the Cicero Institute individual from Texas, who was, I felt, casting assertions on the housing first, person-centered model of helping people exit homelessness. This is an evidence-based solution that has a wealth of research supporting its successful outcomes. The VA, which is an early adopter of the program, has been using that model successfully to decrease homelessness by 52% nationwide, ending homelessness in 3 states, and over 80 individual sort of jurisdictions. So there's documented success for this model. This is what we are the approach that we use in our continuums of care, which are sort of geographic groupings of homeless service providers. There's 3 in Nebraska. So there's the metro area continuum of care for the homeless, which is Omaha metro area. There's a Lincoln Lancaster, and then there's balance of state. Each year we apply for our funding for all of our existing programs. So every year we submit an application for existing programs and what we would like to do. So what kind of things we want to expand into. So this is a really competitive process for really limited funds. for all the COCs across the nation. And it's performance-based. So this year, just in the beginning of February, the balance of state, Lincoln, Lancaster, and Match, we had a record-breaking year. We got awarded $16 million of funding. So as Jason Feldhaus from Match talked about, that's almost $500,000 more than we got last year. And that's because because it's performance-based. That is exemplary of our success in having good outcomes, having high numbers of individuals that exit to permanent housing solutions. And so presenting shelter, those are emergency shelters. Those are not solutions. Those are part of a holistic response, but definitely not a solution. So just wanted to clarify that a bit. It's a complex problem, and I'm happy to answer any more questions about it. There's a lot of elements. So I hope that kind of clears that part up a little bit if there are any remaining questions.
All right, are there any questions for this testifier? I don't see any. Thank you so much for being here. Okay, next opponent.
Hello, members of the Judiciary Committee. My name is Grant Friedman, Grant Friedman, and I am testifying on behalf of the ACLU of Nebraska in opposition to LB 1357. I'm going to try to make this brief, so just straight to the law point. Laws that criminalize homelessness are ineffective, waste limited public resources, and violate basic human and constitutional rights, and strip homeless Nebraskans of their dignity. A federal court of appeals held in Jones v. City of Los Angeles a nearly analogous law that prohibited unhoused individuals from sleeping, sitting, or lying on public streets or sidewalks to be unconstitutional. The court held that the Eighth Amendment's prohibition on cruel and unusual punishment was violated by the law punishing homeless individuals based on the fact that they are homeless alone. Laws like these are not only unconstitutional, but they also increase the cost on taxpayers by officers having to enforce these, jails having to house and feed individuals, and courts having to resolve these matters. For these reasons, we ask that LB 1357 be indefinitely postponed, and I'm happy to answer any questions.
Are there any questions from the committee? I don't see any. Thank you for being here. Next opponent. We seem to have reached the end of the opponents. Neutral testimony. Anyone here in the neutral capacity? This one didn't garner neutral testimony. So I will note for the record that there were 63 letters, 5 of which were in support and 58 of which were in opposition. Senator McDonnell had to get back to Omaha, so he waives closing. That will end the hearing on LB 1357 and open the hearing on LB 974 and our own Senator Holdcroft.
Saving the best for last.
Last 2 hearings of the year, Senator
Yes.
Holdcroft. All right.
Here we go.
Bring us home.
Good afternoon or good evening, Vice Chair DeBoer and members of the Judiciary Committee. For the record, my name is Senator Rick Holdcroft, spelled RICKHOLDCROFT, and I represent Legislative District 36, which includes West and South Sarpy County. I am here today to discuss LB 974. 974 is intended to harmonize the penalty for motor vehicle homicide of an unborn child while driving under the influence under 28-394, with the penalty for motor vehicle homicide of any other person while driving under the influence under 28-306. Under existing law, the penalty for motor vehicle homicide of an unborn child while driving under the influence is a Class 3A felony, which carries up to a maximum sentence of only 3 years in prison. The current penalty for motor vehicle homicide of any other person while driving under the influence is up to 20 years in prison as a Class 2A felony. Additionally, both laws currently provide for an enhanced penalty if the defendant has previously been convicted of a DUI. As it sits now, there is a great discrepancy in potential penalties across 2 similar laws that both apply to fatal crimes committed while operating a motor vehicle while intoxicated. LB 974 would address this inconsistency. The penalties for other fatal crimes having matching penalties regardless of whether the victim was an unborn baby or any other person. These crimes include first-degree murder of an unborn child under 28,391, second-degree murder of an unborn child under 28,392, manslaughter of an unborn child under 28,393, and motor vehicle homicide not while driving under the influence. In all of these instances, Nebraska law recognizes the dignity of the life of the preborn baby by conferring the same penalty classification as that for cases for any other victim. Unfortunately, motor vehicle homicide of an unborn child while driving under the influence is a crime that has occurred with some frequency in Nebraska. And given the loss of life in the course of that crime, the current penalty limiting incarceration to no more than 3 years is simply inadequate. It is unfair to the victim and the victim's family. This bill would offer greater latitude for judges in determining the most appropriate sentence, 0 to 20 years, without imposing such restrictive sentencing limitations. Vice Chair DeBoer and members of the Judiciary Committee, thank you for giving your attention to LB 974. I would appreciate it if the committee would give this bill timely consideration and advance it to the full legislature for debate. There will be a county attorney coming after me who can answer any questions you might have, but I'm happy to answer any questions you might have of me. Thank you.
All right, thank you, Senator Holdcroft. Are there questions for Senator Holdcroft? Senator Ibach has one.
I just have one. Thank you, Vice Chair. Do you know how many incidences there are per year? I'm
I
not
do not have that
minimalizing it.
number.
I just am curious.
I do not have that number, but somebody after me might.
Thank you. Thank you.
Thank you, Senator Ibach. Other questions? I don't see any.
Okay.
You're going to stick around. to
Oh, yeah, I'll
close.
be here.
All right, we'll have our first proponent testifier. Welcome.
Good evening, members of the Judiciary Committee. My name is Ryan Lindberg, RyanLindberg. I am a Deputy Douglas County Attorney, and I'm also here on behalf of the Nebraska County Attorneys Association in support of LB 974. Part of my job duties in Douglas County are to work with a team of attorneys that prosecutes all of the felony motor vehicle homicides, and I've done that in some capacity on a pretty regular basis since about 2011. Under the current law, as you heard, the penalty for motor vehicle homicide DUI of an unborn child is only up to 3 years, which is the only one of those penalties when you go from essentially first-degree murder all the way through motor vehicle homicide that's lower. And I think there's just an incongruence in the law. The purpose here would be to harmonize those penalties. You know, one of the hardest parts of the job as a county attorney is you unfortunately have the occasion to meet with families who've suffered a great loss. And one of the things that everybody wants to know when they ask you is, what are the penalties? If we're able to get a conviction here, what is this person looking at? And, you know, most of the time in cases, you're able to explain, hey, there's a pretty significant penalty here. And this is one that's pretty hard to explain. And when they hear that it's only up to 3 years if a drunk driver has killed an unborn child, and then really you only have to do half of that under our sentencing scheme. So someone would only be looking at 18 months. And it's not a really common crime. You know, we don't have a large number of these. I'd say we get one in Douglas County every couple of years. The impetus for this bill was a particularly tragic case that I had back in 2022 that happened in Douglas County, where the mother and a child as well as another mother were killed by a drunk driver. And that sort of brought it back to the forefront for me and was something that I wanted to address. And that's why this bill is before the Judiciary Committee here today. So, you know, I think it's a worthwhile thing to consider and look at. And, you know, one thing that's worth pointing out too is this is really only a scenario where the evidence would show that a person's intoxication or drunk driving is the proximate cause of the collision and the death. And so that does limit it to, you know, pretty specific factual scenario. And then ultimately the judge would still have the discretion, if you increase this to a 2A penalty, to consider somebody from anywhere from probation up through a sentence of 20 years. With that, I'd be happy to answer any questions.
Thank you. Are there any questions from the committee? I don't see any. Thank you so much for being here.
Thank you.
We'll have our next proponent testifier. It's all right, take your time, it's fine. Welcome.
Thank you, senators, committee members. Good afternoon. My name is Darla Bangston, DARLABENGTSON. I'm here today in support of LB 974. I lost my unborn grandson, Brooks, March 31st, 2022. This is what Ryan was talking about, to a drunk driver. Brooks' due date was just 3 weeks from that day. Sorry. He would have been turning 2 in about 45 days. Brooks was going to be tall. He broke the record at Omaha's Mid-City OBGYN for having the longest femur. His mommy was tall, and so is his dad. I will never know for sure, because the judge was only allowed to give a sentence of 0 to 3 years for an unborn child. But at sentencing, he mentioned that his decision weighed heavy because of the horrific details of the crash. Brooks' skull was fractured from the impact. When the drunk driver ran a red light and hit my daughter's SUV at over 102 miles an hour. The car burst into flames on impact, and Brooks, my beautiful daughter Sarah, and her lifelong friend Amanda were burned. I reached out to my pastor asking for prayers today. He told me that if there is no punishment, people have no incentive to change, and things like this will continue to happen. I would love this bill to be known as Brooks bill, in hopes that something positive would come from this tragedy. Brooks was a little person, just almost ready to be born. Please consider voting to pass LB 974 to allow judges the option to sentence from 0 to 20 years for the tragedy and the intensity of each individual crime. They do need the option to weigh that. Our family has a life sentence now of loss and grief. Thank you for your time.
Thank you so much for being here. I don't see any questions. Thank you so much. Next proponent.
Good evening, Vice Chair DeBoer, members of the Judiciary Committee. My name is Mike Guinan, M-I-K-E-G-U-I-N-A-N, and I'm the Criminal Bureau Chief for the Nebraska Attorney General's Office. I appear before you today on behalf of Attorney General Mike Hilgers and the Attorney General's Office in support of LB 974. The Attorney General generally supports the harmonization of penalties in the Nebraska Criminal Code to promote the consistency between statutes and the fair application of the law. LB 974 is a good example as it harmonizes statutes pertaining to motor vehicle crimes in different sections of Chapter 28 of the Nebraska Revised Statutes. We ask that the committee advance the bill to general file. If the bill is not advanced this year, the review of these statutes could also be included in a more comprehensive review of statutes being done by the Sentencing Task Force. The Attorney General is currently working along with 3 members of this committee on that task force. And one specific area of focus is harmonization of the criminal code for presentation to the next legislative session, 109th legislation. With that, I'll take any questions.
Thank you for your testimony. Are there questions see any, thank you.
Thank you.
Next proponent. Welcome.
Good evening, Senators. Thank you for staying till 6 o'clock to hear the bill. My name is Scott Thomas, SCOTTTHOMAS. And I was just sitting in this chair last week about the same type of issue. Article 3, I gave the same testimony, Article 3, right to life. We heard claims on the last bill being brought that housing is a human right. And I know all 30 of you are enumerated human rights by international treaty, so I don't know if that falls into the scope. I'd like to look into it. But our laws are struggling and our society is struggling right now to define what a human is. And the different delineations being made at different developmental stages are the thing making my work most difficult. So I'm the regional director for the U.S. Institute of Diplomacy and Human Rights for the state of Nebraska. I'm the founder and the principal director of Village in Progress. We do 1948 UDHR casework. And I'm also the father to a 12-year-old girl and a 10-year-old boy. And I make those two distinctly different roles because they're different. And this is a prerequisite for me to do all four of my jobs. The work begins there, when you can find a consensus in the recognition of the humanity of a child. And that lack of definition makes each one of those jobs harder. So in keeping with Article 3 of the 1948 Universal Declaration of Human Rights, we support this bill as an effort to send a clear message that Nebraska places inherent dignity and value on all human life. And the senator is not present right now. I was hoping would be present because the last time that we had an exchange, it was regarding the same issue. She asked me, said, so you're not for privacy protections in law because I'm pro-life. And I said, no, and I thought that was a mischaracterization because I would say my dog doesn't have privacy when he goes outside to use the bathroom, because he's not a human being. And so part of it is connected to our inherent dignity as human beings. And we're human beings. We need to get back to acting like that. That's all I have to say about that. So if anybody has any questions, I'll be open to comments.
Are there questions from the committee? I don't see any tonight, so thank you so much for being here.
Appreciate it.
Let's have our next proponent testifier. Is there anyone here to testify in opposition to the bill?
Good evening, Vice Chair DeBoer, members of the committee. My name is Spike Eichel, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T. I'm appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Defense Attorneys Association in opposition to the bill. I didn't catch the woman's name and testify before, talk about a horrible tragedy that happened to her and her family. My testimony should not be interpreted as being disrespectful to her or against what she experienced. I know that's an empty assurance to her, but I just wanted to say that. Our association has opposed consistently, I think, throughout the year, increases in penalties. And even though this is addressing an anomaly, if you will, in our statutory code, it does increase the penalty. I don't know why there's a difference in the penalty, to be honest, because as Senator Holdcroft explained when he testified and introducing the bill, there's a consistency in all the other homicides with person, unborn child. I don't know why there's a difference here. I can't explain it. I'm just guessing it was not intentional. Perhaps somebody like me didn't sit up in the chair and urge caution in increasing the penalty or creating a new crime. I don't know. As Mr. Guinan explained, there is the LB 50 task force. Those of you who are on the Transportation Committee, this is a similar bill in some respects that you heard earlier this week or last week, I can't remember when, dealing with this type of crime and the different level of punishment and what is appropriate for different levels of punishment. This has the misdemeanor level for motor vehicle homicide for an unborn child that we have in the adult. This does have the felony level, but it doesn't have the same 0 to 20, the 2A felony level as exists for the other crime that we were talking about in transportation the other day. So I know it's kind of rambling, but to be consistent, we do oppose the increase in penalty. If there's a desire to have consistency, obviously the other alternative is to lower the penalty from a 2A to a 3A for motor vehicle homicide involving death of another person. Or alternatively, maybe the task force is talking about this. If you look at our felony level crimes, this is kind of a dilemma that you're sort of forced into, because the penalty levels for felonies are 0 to 2 for class 4, then it goes 0 to 3 years, 0 to 4 years, jumped 0 to 20, and then you're 1 to 50, 3 to 50, 5 to 50, 20 to life. There's really not a lot of moderation there, and you're sort of forced many times as policymakers into sort of figuring out which of these admittedly arbitrary levels you can fit in there. So I know that's not necessarily proposed in the bill. I understand why Senator Holdcroft is doing the bill. There might be some arguments for it, but we would urge the committee to be conscientious and perhaps cautious about just increasing the penalty. And I'll answer any questions that anyone has.
Are there questions from the committee? Senator Decay.
So if I heard you, you're speaking quietly, so
Yes, sorry.
I apologize for not hearing everything, but are you advocating for consistency across the board from different vehicular homicides, so especially when it comes to intoxicated drivers? What would be the problem with life? To me, life is life. So what would be the problem with escalating to the next level rather than trying to climb down the offense to be consistent across the board? Whether we make sure that we can try to keep intoxicated drivers off the road.
I mean, there's an argument to be made on that. That's right. And I try to acknowledge that there is some merit to this bill in that sense, to have it be consistent, because it is consistent as a matter of policy for all the other homicides. Manslaughter, second-degree murder, first-degree murder, there is consistency. There's no difference in regarding the loss of life. I did reference one point that you probably didn't appreciate, because it was a bill that was heard in transportation and that dealt with the level. Oh yeah, of course you did. Sorry. That sort of dealt with that issue, and that you said life is life, but we treat it differently if it's not a driving under the influence motor vehicle homicide. Although to the family and to the people who suffer that loss, it really doesn't make any difference.
Absolutely.
And I'm not trying to trivialize that, but it's a difficult sort of balancing test. Similarly to what I mentioned before on the transportation case, there's still the crime of manslaughter of an unborn child, which is 0 to 20. And now that's a little different elements of the crime than regular manslaughter, but it could apply in some circumstances. So I just mentioned that.
Other questions from the committee? So let me, point of clarity.
Sure.
You're saying that in the other statutes for motor vehicle homicide that don't involve DUIs, but involve some other reckless driving or something,
Right.
that there isn't a distinction between unborn child and adult person?
No, there's a difference in the manslaughter. I can even look at it. It's actually, I think Senator Holdcroft mentioned the statute in his introduction, 28-393, manslaughter of an unborn child. A person commits manslaughter of an unborn child if they kill an unborn child either with sudden quarrel or during the commission of, and then there are specifically limited crimes that you have to sort of be committing that result in a death. For the regular manslaughter, it's any sort of unlawful act.
And are both of those the same level of felony?
Yes, they are both. That's right.
Okay, thank you. I don't see any other questions. Thank you for being here. Next, opponent. Is there anyone here to testify in the neutral capacity? As Senator Holdcroft comes up, I will note for the record that there were 48 letters of support and 1 in neutral. Thank you, Senator Holdcroft.
Thank you, Vice Chair of the Board. Let me just kind of line it out for you the way that the law currently is. I think your question's right on the money. I mean, if it's truly an accident, I mean, a terrible thing, but it is a misdemeanor for the loss of an unborn child. But if there's reckless driving involved, speeding, whatever they determine, but no alcohol involvement, then it is a class 3A misdemeanor, and that's 3 years maximum. If it's a DUI today, it's the same as reckless driving. It's a 3-year maximum. My bill would increase that punishment to a 2A for DUI, and then to a class 2 felony if there is another instance of DUI in the future. So that's kind of where we are. And again, we already have this matchup in manslaughter and first degree murder and second degree murder, where it's the same punishments, whether it is a person after birth or an unborn child. So we're really just trying to harmonize, make everything match up, and correct the current statutes. So I'm happy to answer any further questions.
Are there questions? Senator Holdcroft, I'm apparently dense tonight. So is what you're saying is that the statute for reckless driving for an unborn child's homicide would be a 3A?
Yes.
And then the statute for reckless driving for, let's say, an adult would be something different than a 3A?
I think they're both 3A.
They're both 3As. And so you're saying that what you'd like to do with this bill is say that because all the other ones, it doesn't matter if the child is unborn or born, those things match up.
Correct. So the next logical step is if there's an accident and you have a 6-month-old that's sitting next to a mother with an unborn child, and there's a DUI, and he kills the 6-month-old, then he's guilty of a class 2A. But if he kills the unborn child, then he's only guilty of a class 3A.
And if it wasn't reckless, or it wasn't drunk driving, but it was reckless driving, it
Then-
wouldn't matter between the two.
Correct, it'd be a
children.
3A.
Thank you. That's much clearer. Thank you very much. Any other questions? That will end our hearing on LB 974 and open our hearing on LB 1156.
Okay, here we go. Last one. We do have some handouts. One of our testifiers could not stick around, so we do have a copy of his, which I'm going to pass out with my opening. So good afternoon again, or good evening, Vice Chair DeBoer and members of the Judiciary Committee. For the record, my name is Senator Rick Holdcroft, spelled Rickholdcroft. I represent Legislative District 36, which includes West and South Sarpy County. I am here today to discuss LB 1156. This bill makes retroactive the requirement to register as a sex offender if you are convicted of sex trafficking in Nebraska. It also requires that those who are convicted of soliciting sex in Nebraska or profiting from sex trafficking in the state also be required to register as sex offenders. LB 1086 from 2006 says that no person shall knowingly subject or attempt to subject another person to forced labor or services. Sex trafficking was included in this law. Senator Julie Slama introduced LB 204 in 2022. This bill was amended into LB 1246, which was passed and then signed into law by Governor Ricketts in April of that year. It went into effect on January 1st, 2023. The law states that the Sex Offender Registration Act applies to any person who on or after January 1st, 2023 is found guilty of human trafficking. LB 1156 simply makes Senator Slama's bill retroactive to the effective date of LB 1086, which was July 14th, 2006. Additionally, beginning January 1st, 2025, any person convicted of soliciting sex or anyone convicted of benefiting from or participating in a venture involving sex trafficking will also be required to register as a sex offender. LB 1156 will be administered by the Nebraska State Patrol, as the current sex offender registry is. This bill appropriates $25,000 to fund efforts to locate and notify convicted sex traffickers who will be affected by this bill. AM 2666 addresses concerns presented to us by an organization that works with sex trafficking victims and survivors, and with victims and survivors of sexual and domestic assault. It assures that victims of trafficking are not required to register as sex offenders under this bill. Vice Chair DeBoer and members of the Judiciary Committee, thank you for giving your attention to LB 1156. This is a solid bill, vetted by the Judiciary, law enforcement, and community stakeholders. Several months have been spent harmonizing and cleaning up existing statute and defining the offenses we are pursuing with this bill. Since this bill was proposed to me, I have had independent assurance that it will help to deter those who criminally pursue or who profit from illegal sexual activity in the state. So let me just break here from the text. We're going after the Johns here. This is what this bill is about. And we heard that all day yesterday. We were talking about demand, about the College World Series, about Berkshire Hathaway stuff, that we're not doing enough to deter. Well, this would deter. This would require the Johns to, if convicted, to register in the sex registry. I would appreciate it if the committee would give this bill careful consideration and then advance it to the full legislature for debate. I would be happy to answer any questions you might have. Thank you.
Are there questions from the committee? I don't see, oh, there's Senator McKinney has one.
I guess my only question, just about retroactivity. If we're going back and saying like people who were convicted have to register in the registry, I guess, it goes back like the issue of retroactivity. Did you ask the question of the constitutionality of that? That's just my own question, honestly.
We did. We sent this over to the courts and had an opinion done, and it is constitutional to do that, because this is not a criminal. Being in the sex registry is not a criminal offense. It's actually a civil offense, and so it's civil punishment. And so that is why we could go retroactive. And I think what you're really referring to is what we ran into with LB 50. We couldn't make it retroactive in that, but those had to do with criminal offenses, and this is a civil offense.
Is it? Because if you're on a registry, wouldn't you be convicted of a crime?
You probably would be, but the penalty of being in the sex registry is not a criminal penalty. It's a civil penalty.
Oh, okay. All right, thank you.
I'm sure Spike will be happy to expand on that.
That's a compliment.
All right, thanks.
Thank you, Senator McKinney. Are there other questions from the committee? Thank you, Senator Holdcroft. First proponent.
I've never been here this long.
Oh, well,
Thank you for
welcome.
staying. Chairman Wayne and members of the committee, thank you for giving me the opportunity to speak with you today. My name is Michelle Bang, and I'm currently the Deputy Director of Project Harmony Child Advocacy Center in Omaha. And I'm here on behalf of the Nebraska Alliance of Child Advocacy Centers. First, I want to thank Senator Holdcroft for working on the amendment. Work that focuses on human trafficking that also impacts demand is a goal Child Advocacy Centers support. We work closely with law enforcement, and they tell us that trafficking cases are labor intensive, not just from an investigative point of view, but because of the trauma youth experience. These victims require a significant amount of time building rapport, more time than detectives can give. Supporting victims is a key component of accountability, and victims need support, not only at the beginning of the investigation, but throughout the court process. This is where Child Advocacy Centers can help. Since the inception in 2021, our anti-trafficking youth services program has served 108 kids. 38 of whom are confirmed or suspected victims of trafficking. A confirmed victim simply means that a trafficker has been arrested and charged. A suspected victim has either disclosed or there is strong evidence of sex trafficking. The rest of the kids we serve are at very high risk of being trafficked. The average age is 16, but we have a few who are as young as 10. Prior to my role at Project Harmony, I was a 29-year veteran of the Omaha Police Department, where I retired as a deputy chief. What I can tell you and what the research supports is if people are not deterred from buying an illicit product, be it drugs or sex, there will be people willing to sell it. You can arrest the drug dealer or the trafficker, and a new dealer or trafficker will simply step in to fill the gap. It is estimated that the commercial sex trade in the United States is valued at over $5.7 billion. I would like to say how much of that is the trafficking of youth. I cannot. But I can tell you that youth advertised online in our city are advertised as young adults, or it's not addressed at all. In 2017, there was an online survey of 8,201 men from all demographics that asked them about their sex purchasing behavior. 20% reported purchasing sex once in their lifetime. 6.2% purchased sex within the past year, and a quarter of those men purchase at least monthly. High-frequency buyers tend to be higher earners, pay over $100 per transaction, and account for 75% of the total market. They have normalized their belief that purchasing sex is victimless. Only 6% reported ever being arrested. They asked high-frequency buyers what might deter them from purchasing sex. A quarter of those men reported if the risk of arrest and accountability was high enough, they might be willing to stop. We use this report to make a very conservative estimate of the Omaha metropolitan market, and the estimate is between $10 and $15 million. If you want to reduce the number of Nebraska kids who are being trafficked, we must deter buyers. Recently, an Omaha prosecutor reported to me that the average fine for soliciting prostitution is around $100. That's less than the average price they're willing to buy for sex. Senator Holdcroft's bill is a strong point to hold the correct people accountable for hurting our kids. And I'm available for any questions, and I have a handout.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Next proponent. Seeing none, first opponent. First opponent. Welcome.
Thanks. My name is Jeannie Mezger, Jeanniemezger, and I'm an advocate for people listed on the registry. For nearly 10 years, I have moderated peer-to-peer support groups that include both registrants and their family members. In that time, I have seen wives left to care for their sick and elderly husbands after nursing homes and rehab facilities refuse to admit the husbands because of their registry status. Families stuck in poverty because of registry status, leaving a parent chronically underemployed. A woman who lost her job because her spouse is on the registry. The arrest and jailing of a man for failure to register while he was recovering from a workplace accident that left him a paraplegic. I guess they just couldn't fathom that he wasn't able to get to the office. Families rejected by churches because a family member is on the registry. A little girl whose best friend was forbidden to play with her because her dad's on the registry. A woman registrant, also a victim of a sexual assault, and her address, phone, or her photo, address, and name are out on the registry, so her assailant always knows where she lives. Lifetime registrants living at the Sienna Francis house because they can't afford housing and they can't live with family without the family losing Section 8 assistance. There are also about 278 people on the registry who are listed as transient. Only twice in all that time did I see somebody return to prison because they committed another crime of a sexual nature. This is what putting people on the registry will look like. more people living in poverty, more families isolated from their community, more harassment and vandalism, more broken families, more elderly people denied the health care that they need. The families pay the price of laws like this. I understand why you think it's fine to add more people to the registry, because you can't imagine somebody in your own family being on it. I hope you're right, but at the rate crimes are being added, chances for your grandkids aren't looking too good. Over the last 26 years, the legislature has added crimes in 1998, 2001, 2004, 2005, 6, 9, 10, 11, 2014, 15, 16, 18, 19, 20, 21. Making things harder on the registry makes things harder for their families every time. So I ask you to oppose 1156 and any legislation that would add people to the registry. Thank you.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Oh, you go, Senator Kay.
Real quick. So to not be on a registry because of an act that they committed that might and probably will affect future of that child or whoever, $100 fine is acceptable, rather than being on a registry that's going to try to protect people from being part of that system again.
There's two different things. There's a sentence which the court creates, and the legislature created the rules about that define the duration of somebody's registration time. So in Nebraska, you can be on the registry for 15 years, 25 years, or lifetime.
All right, thank you.
Any other questions? Seeing none, thank you for being here. Next opponent. Spike, do you submit a letter?
No. Sorry.
You can. I'll leave it open till 8 o'clock tonight. Go.
Spike Eichel, S-P-I-K-E-E-I-C-K-H-O-L-T, appearing on behalf of the ACLU of Nebraska and the Nebraska Criminal Offense Attorneys Association as a registered lobbyist in opposition to LB 1156. The bill does two things. It adds the crime of solicitation to a required offense to have to register, and it does make a change that I don't know if I heard the year right, that was passed retroactive to, I think, 2006. A couple of things. Somebody asked, our courts have interpreted in State versus Worm, our state adopted the sex offender registry in 1997. And there was a series of sex offenses that people were found guilty of. They had to register once they completed their criminal sentence. So if you went to jail, went to prison, got probation, whatever, when you got done, you had to register. Back then, it impacted people who were prospectively convicted and anyone who was either on jail, probation, in jail, on probation, or in prison. There were a series of cases where defense argued, said, hey, when I committed my crime, I didn't have to register. That wasn't a thing. You can't make this on me now. You're imposing punishment after the fact. That's ex post facto. And the courts have said, no. The purpose of the registry has nothing to do with punishing you. It has nothing to do with deterring conduct. It's basically to let the community know who's a bad guy when you get out of prison, when you get out of jail, so that we know, people with kids know, if you're a risk to them. Back then, we had 3 levels. We had a low level that the State Patrol would sort of screen, and the probation office would screen people for how much of a risk they were by certain evaluations and so on. The first level cops knew, the second level cops and like daycare providers and schools knew, and the third level everyone knew. In 2008, we did away with all the levels in the evaluation process. Now everyone's on level 3. We also added a whole series of different crimes for deterrent purposes, for other purposes, to include some non-sexual crimes. So now we have everyone on this list that's public, anywhere from 15 years to 25 years to life. We even extended the period of time. So some guys were on there earlier on from the late 90s for 10 years, and they got a letter from State Patrol saying, you're now on for life. Sorry. Or you're on for 25 years. The courts have rejected all of those because it's not considered punishment. What Senator Holdcroft and the proponents of this bill have done is punctured that myth, and that is this. We need to make people who solicit sex have to register because it's deterrence. It's punishment. It's more than a $100 fine. You're going to pay for what you did. And in some respects, no disrespect to Senator Holdcroft, he's sort of jeopardizing that settled case law. If the utility or purpose of this is to deter disfavored behavior and punish somebody who have to register, then you're getting away from that myth of it's a civil sanction. And I think that you do have some ex post facto problems. I don't know how many people are on the sex offender registry. Obviously, Jeannie would know. Maybe she told you, and I was just not listening. But I would submit it doesn't have any real utility to the community, because you look up somebody, they're on the list, and then what? You don't know what level they are. You might know what kind of crime they did, but we have everyone from statutory rape cases, revenge porn, now solicitation. I don't think that's the same as someone who's been found guilty of sexually assaulting a child. It's not the same. And I don't think that's serving its purpose to the people of Nebraska. It may have a deterrent effect for those people who commit the crimes, but I don't think that's the intended purpose. I'll answer any questions if anyone has any.
Any questions from the committee? Senator Decay.
Thank you. Did I hear you right that some people are on a sex registry that didn't even commit a sex crime?
Yes.
Explain that to me.
So if you look at 29, I think it's 4003, there's a handful of about maybe 15 to 20 different crimes: assault, murder, a homicide, kidnapping, burglary, a series of mostly felonies, but some misdemeanor crimes. The judge can make a finding, and actually this bill amends some of those statutes. The judge can make a finding based on either evidence supporting the conviction or evidence that's in the pre-sentence investigation report or materials in the pre-sentence investigation report that justifies making them have to register. And that was a series of arguments that a number of defendants made too, says, hey, that violates what Senator Boz and I were talking about a bill earlier. The judge is making findings after the jury made this, exposing me to punishment. And of course, said, no, that's not punishment. That's just a collateral consequence of your conviction, and the judge can make that finding. And so, yeah, there are some around there.
Thank you.
Yeah. Senator McKinney.
Thank you, Chair Wayne. I don't know, maybe I just should re-educate myself on this topic a little better. But if somebody is convicted of sex trafficking or soliciting sex or whatever, and I guess, are we not changing the outcome of the sentence? That's what I'm confused about, because if they're convicted of it last year or 2 years ago or 3 years ago, and they're convicted of it, and we're saying with this bill, now you have to register. So in practice, like if somebody is convicted of molesting a kid and they're required to register, is that a part of the sentence?
Not necessarily. It seems like it should be, but it's not. So the judge at the time of sentencing will advise the defendant, says, hey, because you've been found guilty of this, when you complete your sentence, you're going to have to register for 25 years. And they have a standard form that the state patrol produces, or maybe the state court administrator's office produces, that the defendant is sort of told to acknowledge. Whether or not sometimes I've had guys that refuse to sign it. It doesn't matter. The judge has told you you've gotten notice, but it basically tells the person you're going to have to register, and generally some of the conditions and some of the consequences. And failing to register and comply with the Registration Act has criminal consequences. If you're transient, you got to do it every 30 days. You have to do it at least twice a year. If you're not transient, you have to notify the local sheriff when you get a new job, new phone number, new address, all those different things. And if you don't do any of those things, you'll be charged with failing to register. And it's an enhanceable crime too. So I've had guys over the years that are homeless that just can't live. They get multiple Sex Offender Registration Act violation cases. They stack them up. It's not part of the sentence. And guys have argued that, lost. Basically, what you're arguing is that, and what the appellate court has said is like, well, it's not a sentence. It's just something that happens to you. It's a consequence of the crime that you're found guilty of. It's like you can't get certain jobs at HHS because you can't get that license. It's not a punishment. It's just a consequence. Now, what Senator Holdcroft and the earlier proponent testified to, I think, make the argument for what I'm trying to make. It is a punishment. It's meant to be a punishment. $100 fine for solicitation or prostitution is not enough. We want you to have to register for 25 years. So I think they are sort of embracing the myth and maybe making the record kind of muddled in a way that they don't want it.
I guess that's confusing. It's not a part of the sentence, but if you are convicted of the crime, you you have to register?
I think personally it's a punishment. I've pled guys to felonies that are not registrable just because with this with a felony, you can get done with your time at some point. You have to register it possibly forever as a sex offender because the guys that are doing 25 years now, the state can always decide to extend it forever for them.
That's weird. Maybe, I don't know. I just probably have to study it better, but it seems like that indirectly is a part of the sentence in a lot of ways, but probably not, but it seems like it is.
Yeah, it is, and it's really unfortunate. It's really important in the juvenile setting because one of the requirements that you have to register is if you move into Nebraska and you have to register in another state. Other states still have those non-public tiers. So there was a case from Minnesota where a kid was in the juvenile court system. He was sexually abused and then he perpetrated on another kid in the foster home. And he was just a really young kid. He had to register in Minnesota, but it was a non-public list. But when he moved here, he got caught up and had to be a public registrant.
Mm-hmm.
And I think this is going to also sort of exacerbate that because it does reference out-of-state required registries being able to register retroactive here too.
All right, thank you.
Any other question? I will tell you that case right there you just mentioned that was in the Supreme Court. That was the case that stuck with a good late friend of mine who was a state senator, Scott Lautenbaugh, who pushed for the law to be changed along with Lathrop and many others during that time. And nobody saw that consequence of the unpublished list in other states. And that was the one bill he would always tell me if he can go back and change, but the political will since then to deal with those individuals has never been there. In fact, 4 years ago, we had a interim study hearing on it and pretty divisive at that hearing. It was packed. And yeah, that was the one bill, and I talked to him about before he passed, if there was a bill he wished he could change, that was the one that he always talked about because of the unintended consequences of so many people who would not be on a public register, but because we don't have one, they're on it. Just bear that in mind for those who are leaving, for those who are staying, I mean. Any other questions from the committee? Seeing none, thank you for being here. Any other opponents? Anybody testifying in a neutral capacity? As Senator Holdcroft comes to close, we had 13 letters, 8 letters of support, and 3 letters of opposition, and 2 in the neutral capacity.
Thank you, Chairman Lane. And thank you for the testifiers who came in today and stayed so late. Really appreciate that. One of the neutral testifiers is from the Highway Patrol, State Highway Patrol. They came in neutral. We did work with them closely to see how much this would cost both for the future enforcement with the Johns, but also with the retroactive piece. And that's where the $25,000 fiscal note came on that. So the onus of this bill really came when I visited Project Harmony. And if you haven't been to Project Harmony, I highly encourage you to go and tour the facility. You know, it's a child advocacy place, but it's much more than that. And they have a sex trafficking task force that's embedded in the basement and with Omaha police officers who were there actively trying to disengage women who are being sex trafficked. Right there down, they have their command center, but right next door, they have all of these nonprofits that are lined up, ready to help these young women get disengaged from their pimps. But I asked the police officers there when I toured, and I said, what can we do in the legislature to try to deter this? And their answer was, put the Johns on the sex registry, require them to be on the sex registry. And so that was really the onus behind the bill. Now, we heard yesterday from Senator Blood, most of the Johns are rich white people who can just pay the $100 fine and not worry about it, but are they really willing to get their name on the sex registry, which is public to all of their neighbors and friends? Now that's a deterrent. And you can argue all day whether it's a punishment or whether it's, just a registry, but it would have the deterrent value that we want. That's what I heard all day yesterday was we need to curb the demand. We need to curb the buyers, and this bill would do that. So with that, I am happy to answer any of your questions.
Any questions? Seeing none, thank you for being here. That'll wrap up LB 1156. And in today's hearings, I'll entertain a motion to go into exec.
Move to go into exec.
Is there a second? I'll